to a different day, to the next meeting, for instance, it would be just like having it this afternoon, as long as it's after the preliminary hearing has already taken place. So I don't really see the need necessarily to table it and take it off the agenda. But I do believe, as you indicated, that we should have the preliminary hearing first, which I believe is what the commissioner, what the chairman of the motion is. Yeah, I mean, I agree. I mean, we have never had a circumstance where we have an advisory opinion on facts that are virtually identical to a preliminary hearing. Fundamentally, I think that creates a number of issues, as no adjudicated body should issue advisory opinions unless, particularly where you've got a live case or controversy, which we have here. I think this advisory opinion should be treated as any other advisory opinion, which is we're opining on future real or hypothetical events. And so my position would be we have to either table that or at a minimum hear it after the preliminary hearing. Hold on, I got all sorts of lights. Commissioner Thompson?
I think we have to be mindful that we have 60 days from the time that the advisory opinion was requested to opine on. So we want to take that into consideration as well. Because if we table it now, when are we going to pick it up within that time frame?
All right. Commissioner Watts?
The advisory opinion request is to
I'm showing something going out,
We're well outside.
and Haley says it's working.
I mean, I'm fine. I'm totally fine with considering it today after the voting hearing. From what I'm hearing, it's got the final thing. But I mean, I don't think we should table this for the day of much longer.
Okay. Secretary Monty?
I was just going to add that issue notwithstanding, if the commission does choose to table the AO, there are always parties involved that want to give more and more input. So there is some value or benefit if the commission goes that route. I heard from a number of legislators about this yesterday during signing time. So there's that to consider if the commission takes that into account.
Okay. Commissioner Barnum?
Sure. In addition to the point that we're well outside of 60 days, which suggests to me that maybe we shouldn't consider the advisory opinion. Even if we consider the opinion after the case, depending on our findings in the case, it will necessarily impact the advisory opinion. Because the facts of the advisory opinion, while couched in a hypothetical, track identically to the facts in case that is 5A on our agenda. If we find cause or a lack of probable cause in case 5A on our agenda, then we could potentially be authorizing an advisory opinion that is directly contrary to or inconsistent with the findings of the commission. So even put the advisory opinion after the case, depending on our findings in the case, the advisory opinion might necessarily have to change.
No, I think that's right, and that's something for the commission long-term to be mindful of. I don't know if there's a preclusion on requesting an advisory opinion on facts that are very similar to a pending preliminary hearing, but it presents a number of issues I think long-term we have to consider. I know we do have the common practice of that 60-day requirement that we don't always give answers in 60 days because we want to be very careful that we're giving the right answer. I don't know how often we have ever given one 60 days. Nevertheless, I agree with Commissioner Thompson. That's something we need to consider. But with that, I will make the motion that we amend the agenda to move up the executive session to the lunch hour and then move up the cases of controversy to Section 3, so that would be above the increased maximum contribution limits and the advisory opinion. Okay, we've got a motion and a second. Any, hearing none, I'll call the question. All in favor, say aye. Aye. All opposed? No. Okay, motion carries 4-1 with one opposition from Commissioner Barr. So first we've got, I will call a case, so that's the preliminary hearings, and that is 20-0072. Oh, thank you. So first up, and thank you Secretary Marty for the correction, is review and approval of meeting minutes for the regular meeting. Did all the commissioners have an opportunity to look at those? And do we have any revisions or changes? All right, hearing none, I will make the motion that we adopt the meeting minutes for the regular meeting on January 7th, 2021. We've got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor, say aye. Aye. All opposed? All right, motion carries 5-0. And so now we're at the preliminary hearings, and the first is 20-0072-C, which is in the matter of Stacey Abrams, and who on behalf of the commission is Mr. Cusack,
Yes, sir.
and who is appearing for Ms. Abrams.
Good morning, Mr. Chairman. My name is Joyce Gift Lewis. I'm here on behalf of Ms. Abrams and the AFT campaign.
Awesome, very good. And do you prefer Ms. Lewis or Ms. Just Lewis? I want to make sure I get it right.
I prefer Ms. Lewis,
Okay.
and it's yes with a hard T.
Got it.
Thank
Thank you, Ms. Lewis. All right, Mr. Cusack, and any materials that you are using, if you have copies, please give those to Ms. Lewis so she has an opportunity to review it.
Commissioners, this is in the matter of Stacey Yvonne Abrams. This is case 20-0072-C. A little background on this case. Ms. Abrams was a candidate for governor in the November 6, 2018 election cycle. Her declaration of intention to file or to accept campaign contributions was filed in our office on May 2nd of 2017. Qualified to run for governor on March 6th of 2018. Ms. Abrams is a former state representative for House District 89 and was the minority leader in the Georgia House of Representatives. The procedural history in this case was filed, a complaint filed by the commission on October 2nd of 2020, and a response was received from Ms. Lewis at the commission on December 7th of 2020. There's three basic allegations made, sort of a broad overview of what we're going to be going into today. These allegations are that Ms. Abrams made expenditures that were not ordinary and necessary campaign expenditures, and they were converted to personal assets. That contributions and expenditures were made prior to filing a declaration of intention to accept campaign contributions, which is a common violation we see. And that
One second, Mr. Cusack, did the commissioners get this copy of this PowerPoint?
I don't believe so. This is just purely for my presentation for me.
Okay, go ahead.
And that there weren't expenditures disclosed made by Ms. Abrams to Sandler, Reef, Lamb, Rosenstein, and Birkenstock PC. The first set of allegations we're going to be getting into have to do with what are ordinary and necessary campaign expenses. And our code in OCGA 21533 states contributions to a candidate, a campaign committee, or a public officer holding elective office, and any proceeds from investing such contributions shall be utilized only to defray ordinary and necessary expenses. And those may include any loan of money from a candidate or public officer holding elective office to the campaign committee of such candidate, or such public officer incurred in connection with such candidate's campaign for elective office, or such public officer's fulfillment or retention of such office. Now, our code defines what an ordinary and necessary expense is, and it's listed to include, but shall not be limited to, expenditures made during the reporting period for qualifying fees, office costs and rent, lodging, equipment, travel, advertising, postage, staff salaries, consultants, file storage, polling, special events, volunteer reimbursements to volunteers, repayment of any loans received except as restricted under subsection I of 21-541, contributions to nonprofit organizations, flowers for special occasions, which shall include but are not limited to birthdays, funerals, attorney's fees connected to and in the furtherance of the campaign, and all other expenditures contemplated in Code Section 21-533. Now, OCGA 21-533C states contributions and interest thereon, if any, shall not constitute personal assets of such candidate or such public officer. You can't use campaign money to benefit yourself personally. That's what that is saying. I'm going to go into what the commission precedent on some of these expenses are, but they have to do with mainly two things. That expenses made to the Commerce Club of Atlanta and Delta Sky Club membership dues by Ms. Abrams. So there are Commerce Club membership dues and Delta Sky Club membership dues. I want to get into the commission precedent on this matter, and it just so happens we have a case that is exactly on point. That was decided, a consent order was signed, and accepted by the commission in regards to Commerce Club dues. And this case is in the matter of William Bill Edwards. Mr. Edwards served on the Fulton County Commission, and in 2015 entered into a consent order and ultimately paid about $13,000 in membership dues to the Commerce Club. And at that time, there were some other violations for failure to file CCDRs, but he entered into a consent agreement in which it was stated that Commerce Club dues are not ordinary and necessary expenses for a campaign because you benefit personally. So he also paid a dollar-for-dollar fine on that for those membership dues, which totaled about a little over $13,000. So that's the commission precedent we're dealing with on this matter in terms of Commerce Club membership dues. There is, if you were the way to properly do this is personally pay for a membership in Commerce Club, and then you can hold campaign events there. But because there is a ban on membership dues coming from the campaign because it's for a personal expense, the membership dues is not allowed to be paid. And I'll get into the reasoning behind that. Now, the commissioners, you may remember there is a similar case that has to do with social clubs with membership dues as well that I think every member of this commission was present for, and that was in the matter of Oxendine utilized campaign funds to pay for membership dues to the Atlanta Athletic Club. And this commission, I think all 5 of these commissioners said that was not an ordinary and necessary expense or a campaign expense. Now, I'm going to get into how these are termed or how these are purposed in the campaign on the CCDRs. This is how the campaign has entered these expenses. Now, if you'll look to the right one, this is every expenditure that Ms. Abrams made to the Commerce Club, and it's titled Meeting, Events, Food, and Beverage. That's actually not correct. These are actually for membership dues. And so the commission staff's position on this is that this is a consciousness of guilt, is that these expenditures are not properly itemized, not properly purposed to mask the fact that these are actually membership dues that are being paid for. These are actually not meetings, events, food, or beverage. If they were meetings, events, food, and beverage, if they were for a political meeting, political event such as a fundraiser, those would be ordinary and necessary expenses, but these are actually membership dues. And you can see from that first check right there, I have circled what those are actually for, what the check states what they are for, and it's for membership, if you can see those 2 red circles.
So Mr. Cusack, how did you believe that they should have been itemized as?
Membership dues.
So is that an option? That's what?
You can input that depending, it's how you input it, how the Abrams campaign would input it. So they would need to input that as membership dues, but this is not for meetings, events, food, and beverage. That's not what these expenditures are actually for. And I'll get a little further into how this has been figured out.
All right, Commissioner Watts, you have a question?
That's fine, I don't want to jump ahead of you, I was going to ask you a question to that.
And I'm about to get to that.
You're fine.
So as part, and going back to this one, as part of some of these documents, these have been turned over. Notice that some of these are redacted, but they've been turned over by the Abrams campaign as part of a subpoena issued in regards to the notice of inspection that the commission did on the Abrams campaign. But we get into the actual Commerce Club billing. Here's what the billing shows. If you'll look here, this is what it's going to say. I'm going to get further down into some more billing that actually shows it's for dues, but they're going to be the same dollar amounts. This is actually not the campaign address that's being billed here. This is the home address. So this is a personal account. You also, as part of the Commerce Club, you get a personal member number. So you can only, so say you go to the Commerce Club, you don't actually pay up front, you're putting it on your member number. So this is wholly just one person's member number. So that's how somebody would be billed, how if you had, you get your billing at the end of the month, but put it on my member number, whatever my unique member number is to me, that's how it is billed at the end of the month.
1 second. Commissioner Barton?
Does the Commerce Club allow for member numbers that are not personal numbers, or do they allow for member numbers for political campaigns?
There is no evidence in this case that this would be used for the political campaign because it's to Ms. Abrams personally.
That wasn't the question. Does the Commerce Club allow for does the Commerce Club allow for campaigns to have member numbers, or for a member number to be something other than a personal number?
You can have a business number, yes, but there's no evidence here that this is for a business number or a campaign number.
I guess, because if the Commerce Club does not allow for a campaign to have a business number, or for a campaign to have a member number at the Commerce Club, how else would a campaign have an account at the Commerce Club if it were not under a personal number?
Could you repeat your question?
Sure.
Yeah.
Sure. So let me just use another example.
Okay.
So if, for example, a law firm wanted to have a membership at the Commerce Club, and this Commerce Club said, well, we can't put it in the name of the law firm, but we can put it in the name of the managing partner of the law firm, and we can put a note on the account that everyone who the managing partner says can use it at the law firm is able to use it, right? I mean, so let's replace law firm with political campaign.
Correct.
Okay, so my question is, does the Commerce Club allow for a political campaign to have its own member number?
Yes, they would.
You've done that research?
No, because I've actually seen other campaigns or other people who, prior to the Bill Edwards consent order, had political campaigns there. It's like having a business account there. You could have that,
Okay.
but there's no evidence to suggest this is a business account because it's billed to the home address and this membership number is paid out of campaign dues, but it's personal.
Well, the circular logic that I'm hearing is, what I'm trying to get to is, if the campaign was not able to have an account number in the name of the campaign, and it had to be in the name of an individual, then wouldn't that have precluded the campaign from opening an account in the name of the campaign? It would have to be in a personal, and it would have to be a personal account?
You can repeat that.
Sure.
Yeah.
But I'm trying to understand, that's why I asked the question. If the Commerce Club, and this is what I'm asking, if the Commerce Club does not allow for a campaign to have a member number, then wouldn't the campaign have had to open an account in the name of an individual instead of the campaign?
A campaign can't have an account.
Okay, that's what I'm asking.
Yeah, I said that earlier, that
Okay.
a campaign can have an account, but I've said there's no evidence here to show that this was for a campaign.
Okay.
All right, Secretary Mighty, quickly.
Yeah, I just wanted to jump in on Commissioner Barton's point. How the account is formed is one thing, how the expenditure is purposed is another, right? So, let's say you have a personal account, you call it a campaign, if it's a personal account, that person can conduct campaign activity there. The campaign activity can be paid for using campaign funds, but the membership dues themselves are to the person. It's the position of the of staff.
All right, Mr. Cusack?
And then we see another check here that's made out to the Commerce Club, and it says again for membership, not meetings, events, food and beverage, it's for actual membership dues. And again, here is an unredacted version. Again, it's Ms. Abrams' personal address, and then showing that this was for dues, and I believe that's going to be in the amount. Let me get that as well. This bill was for $562 for membership dues. And again, here's another check, and again, it says membership for the purpose of this expenditure, even though it was titled meetings, events, food, and beverage. And then here's another one that shows it's for dues. And then here was a receipt that the campaign turned over, which was for $562. There was no corresponding, receipt for this, but this was an expenditure made by the campaign for those dues as well for Ms. Abrams. Now, what exactly do you get with the Commerce Club? Yes, Commissioner Watt.
Go back, explain to me how you figured out those were for dues again? Are you matching numbers?
Yes. So if we go back, so these are $562. If we go back to what the campaign expended, they match up those numbers. The 562 is what's being expended for membership dues.
Right, and so I'm missing something. Where does it say dues?
The campaign did not term these as dues. They termed them as meetings, events, food and beverage. But when we actually get the billing pursuant to the subpoena for the information, that's what's being charged as dues. It's from the actual Commerce Club. The actual receipt is showing these are for dues.
Okay. So again, we're matching numbers. You're
Yes.
saying, okay, so this
Numbers and dates.
This-
Yes.
Did you ask the Commerce Club? Or did anyone at the commission staff ask the Commerce Club whether these were confirmed for dues?
No,
Expenses?
no, this is purely what the Abrams campaign has turned over.
Okay.
So there's checks from the Abrams campaign to the Commerce Club saying they're for membership dues. So we get into what the Commerce Club, what the benefits are, and this is where in campaign finance, wholesale social club or social clubs are just wholesale banned. Memberships to social clubs are just banned because there's so much personal benefit that can be received from it. For the Commerce Club, you get all these perks in the personal capacity of dining, golf, free tea times, preferred dining, discounts on dining. You get swim and tennis privileges at clubs throughout. Anybody in the Club Corp umbrella, you're getting access to those clubs. So that is one thing where it becomes a personal benefit to have this access to all these, perks. You have a wine night here that is in no way could be utilized by a campaign. You have a wine tastings.
So one second, Mr. Cusack. Commissioner Thompson?
If a campaign stays at a hotel, to your argument, there's a bar there, there's a swimming pool there, there's a workout facility there. Are we saying if they were a member, like a Hilton Honor member, that if they used their card number in any way, or the campaign paid for a hotel where they were a member, then that's a problem? I guess I'm really confused why we're so in the weeds. Do we have evidence to show that the campaign or the person, Ms. Abrams, personally used any of these personally?
Well, she had the option to use them, the membership. So the membership is actually what is banned here.
So we're saying, staff is saying, if you have an option to use something personally, and you use campaign funds, even if you don't use it personally, that's a prohibition?
On a social club, limited in this case on a social club, that is prohibited. Now take your hypothetical with the hotel. If you were on the road for the hotel, and I think you used say you had a Hilton card, but you personally paid for your Hilton card, and did the campaign pay for it? If the campaign paid for it, that'd be.
You have to pay for that. You just register. So if I register it to my campaign account, you don't pay for a Hilton card, to my knowledge. I mean, I just think it's a membership loyalty card, okay? But you get perks. Are we getting so far in the weeds that we're going to start regulating that kind of thing?
Nothing of value has been given for that membership card. No campaign expenditures have been made for that card.
But every time I use that campaign, every time I stay at that hotel, I earn rewards. Those rewards are being paid for by the campaign. Are we saying that we're going to start regulating loyalty points and determining whether they were used personally or by the campaign?
No. It is the membership dues to a social club that is the barred activity here. Now, if you're hypothetical with registering for a loyalty card, register all you want, you're not expending any campaign, you're not expending other people's money to get this.
Sure you are. Every time you stay at a hotel and you pay that hotel, the campaign pays for it.
I'm talking about the membership as a Hilton member. In this hypothetical, there is no cash transaction to become a Hilton member. You can stay at a hotel.
Hold on. So, you finish what you're saying, Commissioner Barnum will have a question, and then let's finish the PowerPoint, that way in the efficiency of time, and we can focus our questions in a targeted way. So go ahead.
All right, so,
So, first finish.
I was gonna say, with that hypothetical, the hotel, if you're on the road for the campaign, you can pay for a hotel, absolutely. All right, you can enjoy whatever perks come with staying with the hotel because you're there for campaign purposes. What's here is different. We're talking about membership dues to a social club that is wholly different than being on the campaign trail and staying in a hotel on a night because you're on the campaign trail.
Okay.
That's an ordinary and necessary expense for a campaign.
Got that? All right, Commissioner Barnum.
Here's the issue, Mr. Cusack, I have with your distinction. What you're suggesting is that it's the membership dues,
Dues.
but you're wrapping that up in the fact that there is a benefit conferred to the campaign that is personal in nature. The only difference is that the Commerce Club charges you to be a member and Hilton or Marriott does not. But they both offer benefits to being a member. And what I believe the basis of the complaint is that that benefit is being conferred to an individual and a concern that the benefit itself could be manipulated by or transferred to an individual. If the benefit at the Commerce Club, dinner, drinks, the bar, can then be utilized by an individual, and the benefits of being a Marriott member, a bar at a hotel, club points, etc., can also be utilized by an individual. And if the commission staff's concern is that the benefit is what can be manipulated, what's the difference?
So, what we'll do is you finish your presentation. If the commissioners have targeted questions, I encourage the commissioners to ask it, but debating the merits, let's wait until we hear from Ms. Lewis, because she may also address some of these as well. So,
I mean, as individual commissioners, I think we have the right to get to specific
well,
questions
that's
we
why
want answered.
That's why I said I encourage.
Okay.
I'm not telling any commissioner not to ask a question they have. I'm trying to move this along in an expedited fashion. We're all going to have the opportunity to probe both Mr. Cusack and Ms. Lewis, but we also want to be mindful of time. So go ahead, Mr. Cusack.
And then,
Specific question, Mr. Cusack, if you haven't answered it, is what's the difference between a personal benefit at the Commerce Club being used by an individual and a personal benefit of being a hotel rewards member being used by an individual? What's the difference?
it's going to be fact specific. Now, with your hypothetical.
In this case.
No, in this case, you have the benefit of a social club here. But with using the Marriott Club, there was no expenditure made with other people's money for that access. And in your hypothetical, we are on the campaign trail, and anything on the campaign trail is an ordinary necessary expense if it has something to do with the campaign. Now, under your hypothetical, somebody's on the road, the campaign is not paying for the Marriott access. It's free. Nothing was expended by the campaign. I don't know what the view is, because Commissioner Thompson said I didn't have to expend anything for the Marriott rewards.
That's not what I said. You have to get rewards back to my point, you never answered my question. Do we have evidence that the campaign of Ms. Abrams used the Commerce Club for personal reasons? If the answer is no, then we're saying that just because you have the opportunity to possibly use something personally, the staff's point is that that's a violation. That's what I'm asking, that's a question.
And I'm saying it's the membership dues themselves, which is not the ordinary and necessary expense. Anything utilizing at the Commerce Club, utilizing the Commerce Club for a campaign expense could be, but the membership dues, there is a wholesale ban on membership dues to a social club.
I feel like we're running around in circles. If we go to the staff's litmus test of but for, would she be at the Commerce Club but for she's a candidate? I mean, we're not taking, it doesn't seem like we're taking everything that we talked about in the past on the facts. We're saying that she could potentially, or somebody could potentially use something personally, and I think that's a dangerous slope. Okay.
Then I'll move on to,
Commissioner Wise.
So, yeah, I want to be extremely clear. Do you have evidence that she used the Commerce Club for personal reasons?
based on these, what's been turned over from the Commerce Club, the access to it is, we have the membership dues and that's it. Now, if that's further investigation into actually the Commerce Club, what went on there, then that's something we need to do. But the membership dues themselves is what we're saying is not the ordinary necessary expense.
Okay, well, hold on. But before you can access, in this particular instance, before you can access the Commerce Club, because it is what it is, it's a club, you pay dues.
Correct.
And the only evidence you have, if I'm hearing you right, is that the candidate or the campaign used the Commerce Club for campaign expenses, but for the dues. Is that correct?
There is no evidence either way. There is the access there. They have said that they had meetings, they could have fundraisers, but this is where, if you look to the FEC, there's just a wholesale ban on social clubs like this. It's just
I don't
money.
care.
Right.
I'm asking you the question. Do you have evidence that the candidate or the campaign used the Commerce Club for personal reasons outside of what would be considered a campaign expense?
Not as of now.
Okay.
And that's why we're at the probable cause stage here of going forward and completing this investigation.
Right, so then the argument, just so I'm clear, is that because the candidate or the campaign paid dues to access the amenities of a club, that in and of itself is a prohibition under the campaign finance laws of Georgia.
Yes.
And exactly why is that?
Because it muddies the access to the social club. Now, say for instance, you're invited to be a member of Augusta National, but you don't have the money to pay, but you're a political official, an elected official, and your campaign has the money to pay. You can then pay those membership dues, which is benefiting you with the membership in that regard. So it muddies the water too much on what's personal and what's actually the campaign is benefiting from.
Okay, so then the bright line rule here, and correct me if I'm wrong, is that because the candidate or campaign has the opportunity to use membership at a club for personal reasons, that in and of itself is a prohibition under the campaign, or is prohibited under the campaign finance laws of Georgia.
Yes.
Without any evidence whatsoever that the candidate or campaign actually used that membership for personal reasons. Is that right?
Yes.
Thanks.
And the next one, we have, this is from the first CCDR, the June 30th, 2017 CCDR from Ms. Abrams, in which, or no, it was from the 2018 CCDR, but this is for travel and airfare. Now, these are all Delta Airlines travel, airfare, tickets that were bought. You would expect from a campaign of this nature that there would be some travel going on. Here, this is, and I believe, let me get a better view, February 2nd of 2018 in which a $495 expenditure is made, and it's termed as travel and airfare. Now, we actually matched that up with what it actually was for, and it's for a club membership for the Delta Sky Club. And it's an individual membership, and it lasts, and notice that date, it is January 31st of 2019 that it lasts till. Now, that is after a campaign would be over with. So this is for Ms. Abrams. If you look where it's circled on that first page, it's her specific Sky Miles number, and it's Ms. Abrams in her personal capacity for this individual membership. Now, the same thinking goes along with this membership, is that you are getting these benefits, and I know there is, I presented an administrative dismissal in which during the campaign there was a book tour going on. So there is no differentiation here where she would have access because her campaign paid for it with other people's money for this Sky Club access, but you still get the benefit of going to the Sky Club whenever you're traveling. So it's the same logic with the Commerce Club in that this membership shouldn't be paid for out of campaign funds. It should be paid for personally.
Commissioner Watts, just so we're clear, for now that we're on a different membership, do you have any evidence at all that the candidate or the campaign used the Delta Sky Club within the period that you're referencing here for personal reasons?
Not yet, and that's sort of the reason why we're going forward with this, to find out when we can actually take depositions at the OSA stage and figure out the purview of how much this occurred.
Commissioner Barnum?
And Mr. Cusack, you mentioned this 2015 consent order in the case of William Bill Edwards.
Yes.
The answer, the response to the complaint identifies any number of officials and campaigns that will be covered by the Campaign Finance Act since 2015, where annual dues and membership dues were likewise disclosed on a campaign finance form.
Mm-hmm.
What's the history of the commission's staff prosecution of those matters?
Executive Secretary Money?
Commissioner Barnum, you're referring to, I believe there are two former candidates for officials that are no longer in office, and one that is currently still in office. The one that is still currently in office, we looked into that matter. We obtained records from the Commerce Club. That was a typographical data entry error. That was actually 2 dinners back to back, and if you look at the number, it is not surprising that it wasn't membership dues because it ended in 17 cents, if my recollection is correct. So we have confirmed that that was a technical defect. The campaign has modified the entry error, and we have obtained records to confirm that. As far as the former candidates, candidly, former candidates no longer public officials, we are still looking into that, but that was less of a priority than those who are still currently in office.
Go ahead, Commissioner Barnum.
I'm not sure I understand, but, so Mr. Cusack, what I'm trying to get at is, in the respondents, in the response, there is specific reference to, it's clear here. The response says, respondents state, expenses for the Commerce Club are ordinary and necessary expenses incurred by Abrams for governor in connection with the gubernatorial campaign as a secure, quiet place for meetings with AFG donors, stakeholders, volunteers, allies, and other interested parties, just as a constitutional officer, the Speaker of the House and the Justice of the Georgia Supreme Court, among others, have disclosed in recent cycles. Okay, so what I'm getting, I'm trying to get an understanding of the commission staff's history of bringing complaints under the Act for the campaign expenditure of annual dues, either at the Commerce Club or elsewhere. And there's a 2020 disclosure from a Supreme Court Justice, 2018 disclosure from candidates for office, 2018, 2017, 2016, all of which come after the 2015 consent order you're describing as precedent. So what I'd like to know from you is, what is the commission's history on prosecuting the disclosure of these annual dues as personal expenses stated in the response?
Commission's history, I mean.
Hold on. One at a time. When I call on you, then you have the floor. Otherwise, we're going to be talking over each other. It's going to be choppy and not a pleasant experience. Mr. Cusack, please go ahead.
So, Mr. Edwards, and how this started, just to go back in a brief history lesson. This was a problem pre-2014 in that people were paying membership dues to these clubs. And the commission said, stop. There's a 6-month grace period, or else we're coming after you for this stuff because it's an improper expenditure. Mr. Edwards continued doing that and was ultimately punished. And from that point forward, there is very few candidates, few and far between, who are doing this. Now, obviously, you know how complaints are brought in through a third-party complaint or us on our own cognizance doing it. With those, there's one candidate on there who's mentioned, and which we've already looked into, who's already an office holder. And we were furnished that it was for a political event. We had the receipt, and it was for a political event. It was for 2 dinners. So that one takes away, I guess, the only one that he had. Now, in terms, I believe you're referring to a former insurance commissioner and then a former Supreme Court justice. We're right now looking into those and trying to gather evidence to make sure that it's not the same situation where it's dinners being paid for or dues being paid for. So we have to make that distinction of if they have a personal membership, but then they're holding a campaign event there, that's perfectly okay. But if it's membership dues, that's not okay. So currently looking into that right now to make sure before we file a complaint that it's not actually just a legitimate expense, or if it isn't, if it's membership dues, then we'll file a complaint there.
So you said you're looking into it now. Some of these are 3 years old. Did you just start looking into it now? Because I'm trying to get an understanding of, is this something that the commission staff regularly reviews and brings complaints on? Because at least in the case of, well, you've got Supreme Court Justice, you've got Speaker Ralston, these are 3 years old. You're looking into it now. I'm kind of getting, what prompted you to look into it? Was it the response that prompted you to look into it, or were you already looking into it?
No, the response brought our attention to it, so then started investigating. Unfortunately, we have to be reactive because of the limited resources we have, but the response prompted us to take a look at this as well.
But, so you had the campaign disclosure forms, and you hadn't looked into it until the response, is that right?
I guess we have them in that they were filed, but had I reviewed every single candidates in the state of Georgia's campaign contribution disclosure reports, no, I haven't. I don't have that much time.
Sure. Okay.
Now, here with the Delta Sky Club, it's the same thing. You get this individual membership. You have access to free cocktails, free food, free Wi-Fi in the Delta Sky Club. So it's that blurring of whatever can be benefited personally, but also when you're traveling, you have that personal benefit here. So that's why we have taken this wholesale ban on membership dues to these types of clubs. So in the response from Ms. Abrams, they have stated that they needed a quiet place in terms of the Commerce Club for meetings with donors, stakeholders, and then point out to what Commissioner Barnum was just talking about, some of the people that have disclosed these Commerce Club expenditures. In response to the Sky Club, it was the same sort of reasoning. And upon information and belief, candidates for public office and public officials disclose these contributions or expenditures to travel clubs. I have looked into this one. The only one I can find was the only person who I found that was paying dues, at least that appeared on CCDRs for a Sky Club, was John Oxendine. So I know his history in front of here, and that was the only person I could find who was paying for Sky Club dues out of his campaign fund.
Commissioner Watts?
That's a question I have. Remind me, in the Oxendine case, what evidence we had that, let's just use the Sky Club for example, what evidence we had that the candidate or campaign was using, really, I guess, the candidate was using the Sky Club for personal reasons, non-campaign related.
I believe it was just the dues themselves there, since he had access to it. I don't recall if Mr. Lane, yeah, he was no longer in office at that point, but he was using the leftover funds from his campaign to pay for the membership dues to Atlanta Athletic Club.
So basically, either the office or the campaign was very clearly discontinued
Correct.
at that point.
There was no way it was for a legitimate or necessary expense because he had not been a candidate over the past 4 years.
Okay, that reminds me, thank you. So, but in this case, I understand, I think the Sky Club, what you were referencing a few minutes ago, Mr. Cusack, was that the membership would have ended after the campaign ended, right?
Correct.
But that's, I mean, really, that overlap doesn't mean much because, you know, it's just a difference in dates, right?
Correct.
Had it been extended another year, then we're in an Oxendine scenario.
Correct.
Okay, thanks.
The next one, and these are the violations just listed. There's 6 total, totaling $3,661.51. The next ones we'll get into are pre-DOI contributions and expenditures. OCGA 21530 states neither a candidate who is not a public officer nor his or her campaign committee may lawfully accept a campaign contribution until the candidate has filed with the commission a declaration of intention to accept campaign contributions, which shall include the name and address of the candidate and the name and addresses of his or her campaign committee of officers. Now, our rules go further in clarifying, and on the filing in Commission Rule 189-6-.10, it's the filing of a declaration of intention to accept campaign contributions before campaign contributions may be accepted. And rule number 1 states, no person or campaign committee may accept campaign contributions, including personal loans, prior to the filing of a DOI. Number 2 says, neither a candidate who is already a public officer nor his or her campaign committee may lawfully accept a campaign contribution for a campaign for a different office unless and until that candidate has filed a DOI to accept campaign contributions for that different office. And number 3 is a candidate may not provide a personal loan to his or her campaign prior to filing a declaration of intention to accept campaign contributions. Now, in regards, this is Ms. Abrams' DOI. If you look up in the top right corner, that's when it's stamp filed into our office. It says May 2nd of 2017. And that HDVZ up there, that means it was hand delivered, and our receptionist, Ms. Versi
1
Zanders.
second, Mr. Cusack. Commissioner Barnum?
Yes, Mr. Cusack, what's the difference between an expenditure and a contribution?
Contribution is given to the campaign
Yeah.
by a donor.
Yeah.
Expenditure is whatever the campaign spends it on.
Okay, so,
Just a dumbed down version there.
sure, I get it. Is the Commerce Club, are the Commerce Club dues or the Sky Club dues contributions or expenditures?
Expenditures.
Okay. And so, I assume you'll get there. So as expenditures, are the expenditures likewise supposed to be disclosed? Oh, I'm sorry. Can a candidate also not make expenditures prior to disclosing or prior to filing a DOI?
Yes, and the reasoning, I'll sort of get into that in a little bit, but for a campaign to begin, you have to have money to make, so there's a wholesale ban on contributions before the DOI, correct? You following me there, right?
I am.
All right. Now, in campaign finance with the accounting, you have to have money before you spend money. So you have to take in a contribution before you can actually expend it, or else you have a negative balance, which isn't allowed under our act.
Sure.
So by going off that, you have to take in a contribution before you can actually expend money. So there is a ban, even though it says we have a ban on contributions before the DOI, without a contribution, you can't expend money. So there is a ban on expenditures as well because you can't take that contribution before the DOI.
Okay, I think I follow your logic, but I want to make sure I understand the staff's argument or the position before the commission. Is the staff's position that the Commerce Club dues and the Sky Club dues, that the violation is because they were for a personal expense and not any time. I just want to make sure I'm not confusing the two.
Are you asking if they were before a certain period?
Right.
No, they were during the pendency of the campaign, but
Okay.
we're saying they're not an ordinary and necessary expense and were converted to a personal asset.
Understood. Okay, thank you.
So these are totally separate.
Yes.
Okay.
And then, so we go through, this is filed on May 2nd, 2017. It says at the top today's date, and then at the bottom where it's signed, it says May 2nd, 2017. And I have a better slide of this, but this is the first CCDR that was filed by Ms. Abrams. And there are 3 in-kind contributions that were made on May 1st prior to the DOI that were accepted by the campaign. 2 from Georgia Next, which are in-kind contributions. One is for $1,356.37 for equipment and furniture. And then the next was another one from Georgia Next on the same day for $961 for donor and email list. And the final one is on the same day, May 1st of 2017, from Ms. Abrams' house account for donor and email list as an in-kind contribution, $1,548.
Now, I have a question here. Is there any distinction between in-kind contributions and typical financial contributions?
They're still contributions, treated as contributions. And so here's just a summary of that. That's $3,865.37. Now, there was expenditures made prior to the DOI as well in the form of reimbursement. This was to G Strategies, LLC. This is going back about a month and a half prior to the DOI and making an expenditure, trying to reimburse, I believe, a vendor for when the campaign didn't even exist. So these are borrowed under the act because the campaign didn't exist at that point. So this is $862.78, and it's for taxi service, airfare, lodging, and then more taxi services as well. The final one, this is a legal bill which was turned over as part of the notice of inspection and subpoena that went out. And there are 12 separate dates going back to April 5th of 2017, and if you remember, the DOI was filed on May 2nd of 2017, but there are 12 separate billings there that are prior to the DOI. And so what that shows, even with the redaction, is that there's numerous campaign activity going on prior to the filing of the DOI. Now, I know y'all are well-versed on the commission precedent. We seem to have one of these every meeting of people taking contributions or making expenditures prior to the DOI. This one's a 2012 case in the matter of Demetrius Douglas. And if you look where I've circled, he accepted a personally funded campaign contribution or a loan prior to him filing a DOI. The next case is Norman Garrett, a 2013 case where he violated the act when he failed to file a DOI before accepting contributions and then making expenditures as well. So there was expenditures here prior to the DOI.
1 second, Commissioner Barnum, or I'm sorry, Commissioner Watts.
So, will you tell me what is the sort of precedential value of a consent order on the commission? On an active case before the commission. To me, it's a settlement agreement that you as the staff came up with a candidate or a candidate.
Correct.
I mean,
But ultimately, it's been accepted and voted on being accepted, and that the legal findings, the factual findings, and what's in the consent order has been deemed okay by the commission or deemed accepted.
Commissioner Barnum.
So Mr., well, I've been serving on the commission long enough to know that we often enter into these consent orders because we have a representation from the parties that this is in their mutual best interest. Certainly, and you tell me if going forward it's your suggestion that we have a full-blown hearing for every consent order that's presented, because if that's the case, then we can do that, because I certainly don't expect that, it has not been my expectation that when we approve consent orders, that they'll be brought back as some type of precedential value to us, because we aren't always digging into the facts. We aren't hearing the pros and the cons. We aren't hearing from presentations, witnesses, you know, that's not how we handle these consent orders. So I guess my question to you is it the staff's position, this idea that consent orders have presidential value? Is that a new position? Have we done that previously? Is this going to be the staff's position going forward? Help me understand that.
I believe in our rules, it states that there is precedential value for consent orders going back to, I could be wrong on the year, but it's either 2012, I believe, 2006, so a little wrong on the year, but there is precedential, that these consent orders have precedential value, or precedential, or set a precedent for the commission. Sorry, yeah.
Yeah, fine. Well, since I have your attention, I want to go back a little bit. So you were talking about, a couple slides ago, there were 3 expenditures. Well, I want to get to, in the response, there is, the position is that the campaign filed an amended disclosure form in November. Can you talk about that?
I'm going to get to that, if you don't mind waiting a couple minutes. I actually have a slide on that, and I believe that deals with technical defects. I'm going to get into the definition and how we treat them.
Okay. But that's, those, I just want to make sure we're talking about those same 3 expenditures, but there's one from Georgia, 2 from Georgia Next, and then the in-kind contribution from Friends of Stacey Abrams. Those are the same 3?
Those are going to be contributions as opposed to expenditures.
Okay, thank you.
The next consent order is going to be Dawn Johnson. This is as small as we've gone to. This is a $42 campaign contribution that was made prior to DOI. Same thing with Cindy Jones Mills. She accepted campaign contributions before the DOI. I know this is nothing new for the commission. We take these up pretty frequently, but I'm just highlighting that this is precedent. So here are the violations relating to the expenditures before the DOI. They total right now $25,462.69. Now, we get into the response here. This has to do with the filing of the DOI. And it says, the response from Ms. Abrams was that they sought to file the DOI on May 1st, but it was filed on May 2nd. So May 2nd is when it was actually filed. I've never come across a time where seeking to file something on May 1st, when it's a legal filing, is the legal filing date there. So I don't think that argument holds weight. May 2nd was when it was filed. So that's, I put on there, do filing dates matter? And yes, they do. It shows when the campaign began. Now, here is another continued, and Commissioner Barnum, I believe this is what you were asking about, talking about that they want this to be treated as the safe harbor provision or the technical defects, as a technical defect. Now I'm going to get into what the definition of a technical defect is, and then what our rule says goes further on what a technical defect is, and I will tell you why this isn't a technical defect. So OCGA 21.5.7.1 has to deal with technical defects, and it says the commission shall adopt rules which shall provide that upon the commission's receipt of a complaint, a determination shall be made as to whether the complaint relates to a technical defect in filing. And I will go ahead and say here the commission would not have filed a complaint on this if we determined this to be a technical defect. For this purpose, a technical defect shall include, but not be limited to, a defect such as an incorrect date or a failure to include a date, an incorrect contributor's occupation or a failure to include a contributor's occupation, an incorrect address or email address, or a failure to include an address or email address, an incorrect employer, or a failure to include an employer, accounting errors, or any other similar defects. Now it goes in, we give candidates notice, or campaigns notice that they have 30 days to rectify this technical defect, and if they don't, then penalties start to accrue from there. So that's what Section 2 talks about of how we treat technical defects when they're not fixed, or how we give campaigns the opportunity to remedy them. Now our rules state a technical defect is an inadvertent or scrivener's error in the preparation of making a filing with the commission or with a local filing officer. Technical defects include such mistakes as showing incorrectly or failing to show a date, the contributor's occupation, an address, an email address, or an employer, or any other similar errors, and it basically restates that definition. Now, a technical defect, in this case, what we normally see on the commission or as commission staff would be, say it would be May 82nd. Okay, we all know May 82nd is not actually a day, it meant May 28th, so you have to go back and fix that to May 28th. Here, this is a material change of what this date are. You are taking a contribution that is illegal and materially changing that to something that is legal. So that is not technical, that's not a scrivener's error, you are materially changing the nature of what that contribution was. So that's why it's not treated as a technical defect. We would not have filed this complaint if we believed it to be a technical defect, but materially changing the nature of that contribution is not what a technical defect or how we have treated technical defects before. Now, they go further with the expenditures. The Abrams campaign with the expenditures say they deny that the expenditures were improper, even though they were prior to the DOI, and that they forbid a candidate for public office or her campaign committee from obtaining vendor services prior to filing a DOI, where those services are invoiced at a later date in the ordinary course and where the DOI is filed. Now, they also go on to insinuate that the Kemp campaign had some sort of similar violation, even though the Kemp campaign filed their DOI and every service and every contribution and expenditure is post-DOI. So there is nothing that went back prior to the DOI with the Kemp campaign. So there is no evidence cited. It was just some conjecture that, well, the Kemp campaign did all these things within 30 days of filing their DOI, and so that must have been prior to the DOI. So there is absolutely no evidence to show that the Kemp campaign made any expenditures or took any contributions prior to the DOI. Here is the violations relating to the contributions before the DOI. It is the three ones we talked about from Georgia Next, and then Friends of Stacey Abrams, which is her house account, and then the violations relating to expenditures before the DOI, which was for Delta, Hilton Hotels, Uber, and then taxis, and then the campaign funds for the legal work that was done prior to the DOI. The last sort of violations we'll get into is OCGA 21534B1B, and that states what all reports shall list as to any expenditure of more than $100, its amount and date of expenditure, the name and mailing address of the recipient receiving the expenditure, and if that recipient is an individual, that individual's occupation and the name of his or her employer, and the general purpose of that expenditure. Those all have to be disclosed on the campaign contribution disclosure report. OCGA 21534D, total contributions received and total expenditures shall be reported for the election cycle as follows. It gives that guidance, but all reports shall list the total expenditures made during the period covered by the report, the cumulative total of expenditures made during the election cycle, and the net balance on hand. There was legal work, if we go back to that, and I'll show the invoice that was never disclosed by the campaign, either as an in-kind contribution or as an expenditure. So here, if we go to the invoice that we looked at prior, you have all those prior to the DOI, but they all end on June 30th, which was the end of a reporting period. None of these, and the total bill is $24,599, I believe 61 cents. If we go to all of the Sam Reef expenditures from the Abrams campaign, there is only one, and it is on 12/22 of 2017 for that year, and it's for $5,000. So then that would have to have shown up, even if it was billed later, on the January 31st election year CCR, and it never showed up. So it needed to be either reported as some sort of in-kind contribution, which more than likely would have exceeded the contribution limits, or it's an unreported expenditure that the campaign never reported. And they have just said that they disclose these at a proper time. So that just never showed up anywhere in the proper time period of where it should have showed up.
So hold on, I want to make sure I understand this one. So what's the alleged violation by you for this?
It is a failure to disclose this expenditure
And which expenditure specifically?
to Sandler Reef.
I heard you say that there was a specific entry that was on a date and then other entries were after that date.
So if we go to where this bill, the billing date is July 13th. All of this, I guess with normal law firm billing, is billed during that June 30th CCDR time period. So none of this ever shows up anywhere else in any other CCDRs.
So, okay, so the June 30th CCDR, is it the staff's position that the June 30th CCDR should have included the time for, or the bill for legal services rendered in June?
So it's sort of this either-or argument. It should have been disclosed then, but also it wasn't disclosed anywhere down the line. So it's just this unreported expenditure.
So your position is that these April entries, which were before May 2nd, were expenditures that were incurred before the DOI was filed?
Yes, it was billed before the DOI is filed.
When was it billed?
So there's 12 that go from April 5th of 2017 until May 1st of 2017, which is the day before the DOI.
And it's those entries that you're alleging should have been disclosed on the June CCDR?
Well, those are pre-DOI violations,
Okay.
but they also dovetail into this as this whole bill should have been disclosed in some way, shape, or form. Either on this one, or we're using the June 30th date here, but it was just never disclosed, is what we're saying.
Okay, so the pre-DOI services rendered April 25th to May 1st will go to the issue that I'm sure Ms. Lewis will get into as to whether or not seeking legal advice prior to making a decision to run is appropriate.
Well, to seek legal advice, you don't get billed for that. After an attorney-client relationship is formed, that's when the billing begins. So here you have these expenditures that are prior to the DOI, where I'm not sure you can characterize them as seeking legal advice when they're actually billed.
Okay.
Commissioner Granville?
Yeah, and I think that you just sort of maybe cleared up the air on this, but this the expenditures for these legal expenses, these apply to two different arguments. It applies, number one, to the fact that it was before the DOI.
Correct.
And then secondly, it was never even reported at all.
Correct.
Which is an altogether different issue, which is the one we're on now, which is number.
Yes.
Okay.
Yes. So April 5th, so there's 12 different ones from April 5th to May 1st. Those relate back to what we talked about earlier, pre-DOI, and then the bill as a whole never appears anywhere.
How did we get the invoice?
This was produced through the subpoena from our notice of inspection.
So to be clear, your position is the April entries, expenditures before DOI, and this expenditure was never reported on any CCDR.
Correct.
Commissioner Watts?
I think I'm splitting hairs, but for the pre-DOI argument, is it this staff's position that, let me put it this way. So these legal bills, as you can tell, normally come out a month or maybe even later, right, for expenses incurred in a previous month. So is it the staff's position that the campaign, for the pre-DOI issue, I understand the never reporting. So for the pre-DOI issue, is it the staff's position that the campaign should have, I guess, filed the DOI sooner than April 5th, when the first bill or when the first time entry was recorded on this
Yes.
invoice? Okay, so I I take issue with your point earlier about requests for legal advice not being billed. But that being aside, so what if the campaign didn't know that DL was billing on April 5th?
Should have disputed the bill.
Well, it doesn't really affect the DOI issue that I'm here talking about. So, you know, you say that the DOI, I mean, in this scenario, the DOI should have been filed, in your view, on April 4th, you know, and so, or an hour before this bill occurred. But if I ask for legal advice from a law firm, I don't dictate when that attorney is going to go do it. I can, but a lot of times you don't, right? So what's the campaign supposed to do if you're having these discussions that in your view are non-billable and you don't know when the attorney's going to ultimately go do something?
In the perfect world, you file the DOI and then you seek this out. That's in the perfect world, and I believe the AO sort of speaks to that, but
Mr. Lane, provide their guidance.
Well, and is that the standard, the perfect world, that you're asking the commission to adopt?
well, that's what our law says. So that we have the prohibition of everything prior to the DOI. I'm saying in a perfect world, meaning this is what our law says, this is how we have to apply it. I know we don't live in a perfect world.
Right, and the response, though, makes it clear that a campaign's efforts to seek legal advice on any issue related to running for office, including what, you know, filing requirements or deadlines or whatever it may be, prior to actually going forward, the response on that is how can one seek legal advice on whether or not you're going to run for office before deciding to run for office and then disclose that? I mean, if I'm understanding the response's position, so yeah, whoever wants to.
I'll let Mr. Lane speak to that. He worked on the.
Sure.
Mr. Lane, welcome to the party.
Thank you, gentlemen. I'm enjoying the discussion. It's going to help the AO. I'm excited.
If we get there.
If we get there. I mean, I've got a feeling it might be taken.
This is the projector.
As far as
Fixing
the
commissioners, so
taking of legal services and advice,
if
what
Joe
commission
moves the
staff's
slide, you
opinion has
move the
been
slide here
all
as well.
along, that's
Oh, I
kind of
see what you're
tracking
saying.
into what you
I need to
find
get out.
normally
I'll be
happens
right
in
back.
practitioners in campaign finance law. You have to make a distinction between, are you a candidate at the point you're seeking the legal advice? Because we don't regulate what a private citizen does. We regulate what a candidate does. And the code defines a candidate as someone who's taken affirmative steps to seek nomination to office or nomination for election and election to office. So if I stumble into your office, Mr. Barnum, and I say, hi, I'm Robert, I'd like to run for governor, can you tell me what I need to do? I haven't entirely committed to running at that point. I'm seeking legal guidance, so I have not met the definition of a candidate. That is not a contribution for which a disclosure has to be done. Now, to change the fact pattern a little bit, if I come in and I say, hi, Mr. Barnum, I have created the Robert for Governor Campaign Incorporated. Can you tell me everything I need to do now with the Campaign Finance Act? I am now a candidate subject to regulation under our act. And then the question becomes, is your legal advice a contribution under Georgia law? What a lot of practitioners do when they are being solicited to provide services or you're doing that initial client consultation, most people don't bill for it simply because they view it as a lost leader. You want the business and you're going to make it kind of up on the back end. And if you are giving legal advice, while it may be substantive legal advice, it's volunteered services. And volunteered services for which you do not charge, even if they're professional services like accounting, legal work, what have you, is not a contribution under the definition of a contribution because there's a carve out for volunteered services. Additionally, looking at kind of substantive legal advice, we're looking at how, to us, there's a little bit of a difference between, like if you just say off the cuff, well, you need to go file a DOI and then we'll talk about it. Here, let me log in right now and file it for you. That's really not substantive. To us, that's not substantive, but if you're saying, well, here, you need to file a DOI, you need to incorporate your campaign, you need to do X, Y, and Z, and oh, by the way, let me help you draft your incorporation, you've now crossed into substantive legal work. And if you're billing for it, it's not volunteer services. It meets the definition of contribution, and since you are now a candidate, and it's a contribution, it's subject to the prohibition on the DOI. You can't accept for DOI.
So then, what I'm hearing is part of the issue comes down to what the individual says to the lawyer when they walk in.
Correct.
Okay, and in this instance, what evidence do we have as to the conversations between Ms. Abrams and the lawyer? My guess is none, because it's attorney-client privilege. Or do we know what Ms. Abrams or the campaign or whomever said to the lawyers when they walk in?
And I'll defer to Mr. Cusack on the evidence, but in like the realm of a hypothetical.
Sure.
We look at the actual services that are provided or that are contained in the invoice.
Right.
So if it says something like an hour consultation, you know, it's hard to prove, but if we see like filing fees for registrations, if we see other like reimbursable expenses that a law firm customarily gets like reimbursed for, they've gone beyond just the, well, let me talk to you about the way you think you need to be a candidate, you might not want to be one. At that point, it's kind of evidence that you've made that leap to, I am now a candidate and I'm proceeding forward.
Got it.
So let me ask this. If an individual is considering a campaign, they incur personal expenses which they do not seek reimbursement for, would that be an expenditure?
No, sir. Well, it's an expenditure, but it's not a campaign contribution or campaign expenditure for which we regulate. You are allowed to spend your money as you see fit.
It's not a loan?
No, sir, because at that, like, in the hypothetical, if I heard it, Mr. Chairman, is I'm thinking about becoming a candidate. I'm seeking legal advice on what would I have to do if I made that decision to become a candidate. I'm not, at that point, a regulated entity under our act because I'm not yet a candidate.
Yeah, well, to me, I think the distinction is whether you seek reimbursement.
That does make a very big difference.
So if, it's not that individuals can't get legal advice, they can.
Correct.
But if they seek reimbursement for it, then that implicates the Campaign Finance Act,
It does.
which implicates the reporting requirements.
And the only slight exception that the reason the candidate distinction is important is because since 1979, the Supreme Court has held that if you are a candidate, the expenditure of your own personal money is a campaign contribution and expenditure subject to reporting. So that's why we have to make that distinction of are you a candidate, yes or no? Because even if you are a candidate and you're making your own personal expenses and you don't seek reimbursement, it's still a campaign contribution and expenditure because even your own money, once you are a candidate, is a campaign contribution.
But isn't that circular reason? I mean, you don't become a candidate before you file a DOI.
You can actually, when you read like the definition of candidate, it's qualifying for office, which is not filing of a DOI. The filing of a DOI, or the making of campaign expenditures or the acceptance of campaign contributions. So a campaign contribution and campaign expenditure is defined as roughly anything that is made for the purpose of affecting your nomination to office or your election to office. So if the purpose of me spending the money is to determine whether I'm running or not, that's not moving me forward in my election or my nomination. It's a little nuanced, but it wouldn't meet the definition of contribution or expenditure. It would be like a separate category unto itself.
All right, I think there'll be follow-up on this. Commissioner Wise.
I'm having a really hard time understanding this very, very fine line we're paying for a campaign expenditure. Contribution, pretty easy.
Okay.
But under your reasoning, the gas that I just used to get to the lawyer's office because of whatever's in my head about what I'm thinking about asking on this particular, whether I should run or not, is now an expenditure. I mean, so I practice securities litigation, and there is a term called scienter that we spend a whole lot of time talking about. And we as a commission staff are deep into the frame of mind of a particular candidate right now to determine when they should have filed this DOI. And to me, I'm very uncomfortable saying that us looking at whatever's underneath that redaction and somehow deciphering whether they've gone far enough to affect their, potential nomination.
Well, and I don't mean any disrespect like this, but your gas in your car is not a campaign expenditure of yours, or you disclosure on the hypothetical you just gave.
There's a lot of other expenditures I can dream up that would under your reason.
It could be, but at that point, you would meet the definition of candidate. No,
Why?
Well, here's where.
Because you decided it?
Well, unfortunately.
Mr. Lane, get a little closer to the mic, I just
Sorry.
want to make sure everybody.
I do apologize, hopefully that's better. In everything we do, it's going to be highly fact-specific. I think you would have a very hard time, and I don't envision you would ever have staff or a commission that would say, well, someone expended $150 to get general legal advice, ooh, therefore they must automatically be a candidate, and we must nail them to the cross. Not always, I have done that. But, and I tend to be one of the harsher people on commission staff with following the law. However, if you do have an instance where someone has expended $50,000 on services, whether it be legal, vendors, what have you, and then they come in and say, oh, well, I hadn't made up my mind to be a candidate yet, I think the commission could find that argument to be disingenuous.
But you're talking about, you're talking about 5 of 25, right? That's what you're taking issue with. Because they filed the DOI on May 2nd, right? And I think from April 5th to May 1st, if I'm reading the screen correctly, is around 5,000. Isn't that what one of the slides said?
We don't know how much the number is. If you look on there, there's filing fees that predate the DOI.
Understood.
Yeah.
But what we're divining here is that whatever is said underneath that redaction between April 5th and May 1st was enough to make you, potentially a candidate under the law.
Correct.
And I'm not gonna ask here what's underneath that redaction.
Do you know? I mean, you got it redacted, I assume, right?
Yes.
So you don't know what's on it?
I would just remind, we're at the probable cause stage right now of seeing 12 expenditures prior to.
But you're asking us at the probable cause stage to give you leeway to guess what's under there.
Well, I think to further investigate what's under there, but yeah, go ahead, Secretary Meyer.
To that point,
Sir.
To that point, Commissioner, neither Mr. Lane nor Mr. Cusack were involved in the records inspection. I was. They were unredacted at the time. I don't remember all 25 lines from how many years ago, but I do recall that one of them was billing for articles of incorporation. So we have some idea that actual legal work for the campaign incorporation was done.
I think there'll be some follow-up here, but go ahead. Oh, hold on, Commissioner Thompson, you got a question?
To this point, I have a question. So under the staff's reasoning here, a campaign cannot file an RC that they've been incorporated at the same time they file their DOI because they must have paid the corporate registration fee. Because that's one of those expenses you're talking about filing fees. So the staff, sounds like their opinion is you have to file your DOI, wait till it's filed, then you incorporate your campaign like a lot of campaigns do. Because if you do it at the same time, have you just not violated what you're talking about?
As a Supreme Court justice said in 1979, the Campaign Finance Act is not the model of precision in drafting. I think that's probably an understatement. The way the law is currently drafted, Commissioner Thompson, you are absolutely right. If you were going to be entirely 100% in compliance with the Campaign Finance Act, you would file your DOI first, then pay for the legal incorporation of your campaign, and then file your RC. Now, thankfully, our new filing system will allow almost the simultaneous filing of your DOI when you choose to do it. So in the hypothetical, if someone comes into Mr. Barnes' office and says, I want to run for governor, I'm hiring you, he can literally log on with his computer and file right then and there the DOI, and then everything from that point on is completely legitimate. There's no longer a mail delay, or you have to run it to the commission to get it physically filed. The computer system does it for you automatically upon registration. So, I mean, there's no perfect,
Is that what happens? I mean, realistically, practically speaking, you have investigated probably thousands of campaigns.
yeah.
Probably, and this issue, I assume, is not the first time this case is not the first time you've seen this issue.
That would be a fair statement.
Right, is that practically what happens?
No, and generally where the distinction you find, at least for us, from making an issue of it, is the amount of services that have been provided. Very rarely are you ever going to see us go, well, I know he spent $50 incorporating his, campaign, or whatever the incorporation fee is today. And, they spend an hour with the attorney at lunch discussing what they're doing. Let us say that's all before DOI, let's go after them.
And where do you draw that line? $100? $500? $5,000? $10,000? $50,000?
I hate to punt, but we kind of leave that to the commission's discretion to give us guidance on where that line should be. If you're personally asking my personal opinion, I think several $1,000s at that point, I think you've lost the ability to claim that I'm thinking about being a candidate. I think you really have. At that point, you've crossed the line. But as far as exactly where would I draw that line, I'm going to have to defer to you gentlemen, because I'm afraid that's your call, not mine.
I guess that's where I'm having, especially in this scenario, with the legal advice, a really hard time, because you can ask for a whole, you can talk to your attorney on monitor things, right? Then all of a sudden DL hauls off and starts looking at God knows what, and about campaign laws and incorporation and everything else, and you didn't know that, okay? So then fast forward a few less than a month later, and now I want to be a candidate, so I file the DOI, right? Then I get my bill in July, and I realize, oh no, DL may have crossed the line. What are you supposed to do? I mean, no one, and I would be annoyed if people did this, call me in the middle of the month and say, send me all your time entries right now. I gotta know because it's a dire situation under the law. I mean, I feel like we're asking a lot of candidates.
Well, and to an extent, I would respectfully submit that you're asking a lot of their lawyers. I would encourage candidates not to go attorneys who dabble in campaign finance, actually go someone who does it on a regular basis, because they will make sure not to send you a bill for several $1,000s prior to the DOI. It just won't be done. They'll know not to go down that rabbit hole with their client and do thousands of dollars worth of, frankly, unauthorized expenses and then bill them on the back end. We can't craft
that's what you're talking about, right? So I mean, if Mr. Chalmers was here today, I would ask him this question directly, but I mean, are you saying?
Be careful, sir.
He's with us and scared.
Oh, good, get him on Zoom. No, I'm serious, but so is it, are we expecting a campaign finance attorney with experience in this field to say, all right, I'm going to do X amount of legal work for, the first 3 weeks in April. You let me know when you file your DOI, because after you do that, I'm going to load up on the bill on what I did for the last week.
And I'm going to be very honest with you, Mr. Watts, that I basically polled every practitioner who does campaign finance law in Georgia on how they do their billing. Very rarely do you have someone who comes to them, Pollyanna, I don't know what I'm doing, I don't know if I'm going to be a candidate. Most people at that point know they're going to be a candidate and have taken affirmative steps to be a candidate.
Hang on, Mr. Mayor, but what it sounds to me like, right, in certain circumstances, we should analyze this based upon what we know actually happens.
Correct.
But where does that perfect world stand? Because not 30 seconds ago you talked about, well, what people should really do is go to a practitioner who knows campaign finance law, so they know how to work around the rules. That's not practically what happens.
Correct.
So, I mean, are we gonna talk about what practically happens?
And I think that's where you get into the nuance on where does the commission exercise discretion where, for lack of a better term, you choose not to prosecute.
Okay.
For example, what is that line? What's the amount of legal work where it no longer passes that, logical test of that you're, and I hear what everyone's saying. I'm not trying to discount it. But you have someone who doesn't know any better. They go to someone who doesn't practice campaign finance law. They, the attorney doesn't know any better, and I'd argue commits malpractice by billing for things they shouldn't.
Let me just get, so effectively, the argument is that if you incur any expenditures prior to the DOI, that's a violation. Hold on, let me finish. This qualifies an expenditure if an individual takes certain steps to cross the line into a candidate. The commission has to evaluate whether or not certain steps have been taken to declare that individual a candidate, to trigger whether these qualify as expenditures that require to be reported.
You have that exactly correct.
But that's what we've got to evaluate, and we'll hear Ms. Lewis on it as well.
In closing, I would just like to point out the filing fees that predate the DOI there. So there are the steps that are taken to be a candidate in those filing fees. But with that, I will turn this over to Ms. Lewis.
Okay. Thank you, Mr. Cusack. Ms. Lewis, we're ready when you are.
Thank you very much. I have a PowerPoint presentation I want to talk about.
Erwin, can you help with that? And I might take a 2-minute recess break while they're doing that.
That's good.
Second.
Sorry for not waiting for Greg.
Been fine so long. Okay, good.
Yeah, she said she just had a little bit of trouble at the beginning, but then it connected. I'm glad you did speak.
Just do it in your box. Email it, yeah. Oh, I sent you the opinion article too. You're tired to read?
Are we on pause? Are we still streaming right now? No audio.
Yeah, no, really.
You want to look at it?
All right, Ms. Lewis, we're ready. Take your time. If you're ready, we're ready.
Okay, so I appreciate you bearing with me and just. I appreciate you bearing with me since I'm not familiar with this particular laptop, but I'm going to do my best, and I appreciate the technical assistance. Good morning. I would like to begin by saying that a number of the questions that the commissioners raised during Mr. Cusack's presentation are questions that really do need to be answered. And I think part of what underlies that questioning, when we're talking about things like slippery slopes, when we're talking about things like fine lines, is what was the motivation for deciding to try to make an example here with this particular campaign? We have provided to the commissioners a response to the proposed advisory opinion, and I understand that the discussion of that is tabled until later on this afternoon, but I would hope that you would give the response some serious consideration. And the point about the advisory opinion and the facts in this case being related is well taken. If there's a need for us to request guidance, it's because the guidance that was there was not clear to begin with. And just as a matter of principle, the point for having these guidelines and rules is to have transparency and to have a campaign be able to know what it is and what it is not allowed to do. The point, in other words, gentlemen, is not to play gotcha with campaigns. So let's go ahead and start talking. So I want to start with the October 7th, 2020 complaint. Now this complaint incorrectly names only Ms. Abrams as the respondent. You will note as we go through, however, that the allegations that are complained of actually inure to AFG Group, Inc., which was the incorporated campaign committee that was responsible for reporting campaign expenditures and contributions. As I believe everyone here knows, this campaign was the largest in Georgia history. And judging from this complaint, it was extraordinarily well run from the standpoint of financial reporting and fiscal stewardship. The campaign's records were previously subpoenaed by commission staff. Over 4,000 pages of receipts, invoices, and other financial records were produced in 2019. And this is what the commission staff has come up with based upon those document productions. A complaint that does not allege that donor funds were mishandled or unreported, does not allege that AFG violated limits on campaign contributions, does not allege that AFG was not transparent. And the expenses at issue for purposes of this complaint amount to approximately 1/10 of 1% of the total expenditures for the campaign. And this complaint should be dismissed. There are 3 primary allegations. And Mr. Cusack touched on this. The first allegation is that there were 3 misdated contributions, in-kind contribution entries totaling less than $3,900. These were technical defects that were corrected on November 4th. Mr. Cusack, without evidence, has asserted that the corrections that were made were improper. The campaign will be able to demonstrate that the dating of the in-kind contributions was intended to match the dating of the DOI, and the DOI originally was believed to have been dated May 1st. The in-kind contributions came after the DOI was filed, and the technical defect corrected that date to May 2nd. in addition to the technical defect issue, which has been corrected and which under the statute should no longer be at issue in this case.
Now, which ones are those?
These are the Georgia Next in-kind contributions. In addition to those technical defects, which as I said were properly corrected as the campaign was allowed to do under the statute, there is an unprecedented assertion that post-DOI payments to legal counsel and vendors will be deemed the equivalent of accepting pre-DOI contributions. There's also, pardon me, I don't think my clicker is hearing me.
So that says post-legal DO payments will be deemed as pre-D contributions. Is this in-kind contributions?
No, no, no. These are the payments to the legal counsel and the vendors that Mr. Cusack was talking to you about. The staff is asking the commission to deem the payments to those legal counsel and vendors after the DOI was filed to be the same as contributions received pre-DOI.
Would that be an expenditure or a contribution?
An expenditure is an expenditure. It was an expenditure when it was made, and we'll talk about that a little bit later on in the presentation. And I apologize, but this clicker does not seem to be advancing me to, it will go. Thank you. And then the last issue is the unsupported claim that campaign expenses for quiet, secure meeting space should be deemed extraordinary and unnecessary. And the commissioners correctly question the basis for that assertion, and there really is none. There's no support for the proposition that the meeting space that was purchased was extraordinary or unnecessary. So let's start with the legal counsel issue. Meetings with legal counsel are not campaign contributions. In its January 31st, 2018 CCDR, AFG properly disclosed payment on a July 12th, 2017 invoice to its law firm, San Lurie. Now, Mr. Cusack incorrectly stated that the payments to San Lurie in connection with this July 12th invoice were not properly or timely disclosed. I believe at least one of the commissioners noted the fact that if the reporting period ends on June 30th and this invoice is not dated until July 12th, it's not surprising that this invoice did not show up on the June 30th CCDR. It did show up on the January 31st, 2018 CCDR. There was a $5,000 payment made towards the balance of this invoice. And the remainder of this invoice was paid in subsequent months and reported properly on the CCDRs that were applicable to those time periods. The commissioners also noted, and I believe this was
Hold on 1
Commissioner...
second, Commissioner Watts.
Real quick, just while we're on this topic, is there any legal expense that was incurred either prior or post DOI that never showed up on a CCDR?
I'm not aware of any, no.
Is that an allegation about the staff? I thought that was, that's why.
It is. I think it is.
Okay.
Mr. Cusack.
I think where staff's confusion is that the campaign did not pay this invoice all in one lump sum. They paid it over time. And as lawyers, we know that sometimes we have clients who pay invoices over time as they can, as opposed to paying an invoice all at once. And that's what occurred here.
I'm sorry, Ms. Clarify that for me again. So the staff's allegation is that there were payments or expenditures that were not disclosed on a CCDR at all, as I understand the allegation. What is the campaign's response to that?
The response is that the expense was properly disclosed and the payments, the expenditure, the payments for the expense were also properly disclosed. I think staff's confusion is the fact that rather than paying the full face value of the invoice in one lump sum payment that was then reported on an expenditure report, the campaign paid towards the balance of the invoice, beginning with a $5,000 payment in December of 2017, which was reported on the January 2018 CCDR.
And so would there have, to the extent future payments were made, were those future payments disclosed on future disclosures?
Yes.
All right, Commissioner Cranfield?
Which disclosures?
I do not have that information in front of me for purposes of this PowerPoint, but I can certainly provide that information to you, Commissioner Cranfield. All of the expenditures for the purposes of paying campaign counsel were disclosed.
Because I think what we were talking about was around, and I'm just rounding the numbers, I think it was around $25,000 that we were talking about in this bill.
Correct.
So you're saying that this 13118 CCDR had $5,000
Correct.
of that 25 reported on it.
Correct.
And so you're saying that there are CCDRs after 13118 that contain the rest of that $25,000 and it was reported?
Yes.
I mean, I think we need to know when that was and we need to see those CCDRs.
Okay. We can certainly provide those for you. And I believe it was Commissioner Watts that was noting the fact that the invoice itself did not contain a single month's worth of time. It actually contained time from April 5th through June 30th. And also noted by Commissioner Watts, only a portion of those time entries by the attorney would have been before the DOI was filed. And it's undisputed, and I think this is important for purposes of our discussion, that the campaign was not billed for that time in April. The campaign was billed months after it filed the DOI. DOI is filed May 2nd, the campaign receives this invoice on July 12th. So let's talk about what staff is asking.
Commissioner, it's hard keeping everything going. Go ahead.
So just because I think this is the perfect time to ask this, so it's your position that when the campaign was actually billed is when the expenditure occurred?
It's my position, and it's this commission's position, and it's the statute's position as to when an expenditure occurs. And we'll talk about that a little bit later on in the presentation, but an expenditure occurs when it is paid. And it's, precisely for reasons like this, that you don't necessarily know what a vendor is doing work on your behalf, but what you do know is when you receive the invoice and when you pay the invoice, and that is what the campaign has control over. So, in order to find reasonable grounds that a violation occurred with respect to these payments to legal counsel, Commission is going to have to find, contrary to the plain language of the statutes and the rules, that 1, expenditures occurred when services were received rather than when they were invoiced or paid, and 2, that meetings with counsel before May 2nd were expenditures that should be deemed to be campaign contributions in violation of 21.5 G30. So let's talk about what is the Declaration of Intention form. Declaration of Intention to accept campaign contributions. It does not say Declaration of Intention to start a campaign. It does not say Declaration of Intention to meet with legal counsel. It does not say Declaration of Intention to engage a campaign vendor. It says Declaration of Intention to accept campaign contributions. That is what the candidate and the campaign execute. There's no benefit that has been enunciated here today, and none that we have been able to come up with from interpreting contributions to mean anything other than contributions, other than, of course, giving staff the ability to claim that there's been a violation by this particular campaign. OCGA 21-530, G.
1 second. All right. Commissioner Greenwood.
What about the staff's argument that, even though it only references contributions pre-DOI, that you can't go into the negative and therefore it necessarily would include expenditures as well?
But you're not going into the negative because you're not making an expenditure until you pay for it. And maybe we should jump to that a little bit more quickly because I think other folks have questions about that as well. But there is no expenditure until the money is actually paid. So there's no issue of going into the negative. What we're talking about, if we're talking about anything, is potentially incurring an obligation that you may have to pay someone later. We're not talking about receiving a bill. We're not talking about an invoice being issued. We're talking about the spending time with a consultant or spending time with your legal counsel and the staff asking this commission to equate that to accepting a cash contribution out of a potential donor's hand. It's not the same thing. And in addition to the form, I would direct you to the statute itself, which references contributions only. It says nothing about expenditures. And on that note, I will mention this. The people who came up with this statute, the people who drafted it, are legislators who have to run for office. So surely, if they had intended that the statute prohibit expenditures on behalf of campaigns before a DOI, or prohibited, rather, a campaign from doing anything that would potentially lead to a campaign before executing a DOI, they had the opportunity to include that language in the statute that they drafted. They did not. And the lawyers among the commissioners will know that in Georgia, the default position is if the legislature has the ability to reference a particular word and they choose to use a different word, that has meaning. That is not accidental. That is not deemed to be something that is non-consequential. So let's go on to what else the legislature has done.
So what's the AO that says that expenditures can't take place before the DOI? Have you seen that one? I don't know what number it is, but there's an AO that says expenditures can't take place before the DOI.
I have not seen that. Okay. If you would care to direct me to it, I'd be more than happy to look at it.
I think, Mr. Cusack, are you aware of that?
I haven't seen it in a long time. I don't know it off the top of my head.
Okay.
It's either AO 2020-02 or AO 2020-03.
Okay, so it would be an advisory opinion that post-dates the activities that we're talking about here today, which occurred in 2017. Thank you, Mr. Lang. Any other questions, Mr. Chairman?
That's it.
Okay. So let's go to what else. Let's go to what else the legislature decided to do. The legislature decided to define contributions and expenditures separately. OCGA 21-5-3. Again, there's a reason that they did that. There's a reason that contributions and expenditures have different meanings. Let's look at the commission's own form, the CCDR. It separates contributions from expenditures, consistent with the definition on the statute. Now, presumably, the commission also has a reason to treat these as separate categories to be reported. And there's really no basis or precedent for the argument that is being urged by staff here today in support of this complaint and in support of the notion that these things are the same for purposes of an alleged violation of the Declaration of Intention requirements.
Commissioner Watts?
So, the timing of the DOI, I mean, if it's only, in your view, about being billed, once you receive the bill, once you've been invoiced, or whatever it is, you don't need to file, is it your view, or, is the law that you don't need to file the DOI, even though you've taken, I mean, obvious steps to become a candidate, right? Let's not talk about the line, it's just obvious, right? You're gonna become a candidate for whatever office. But everybody's been doing it for free. Or everybody's been planning, you know, all the vendors and legal counsel, whatever, planning to invoice you, but they're just withholding until you file that DOI. So is none of that occurred, the obvious expenses, you know, that have been incurred that you're gonna get billed for later, as long as you don't get billed for it, you don't have to file the DOI?
The DOI does not require you to file under that circumstance. I would say as a practical matter, you're going to want to get your DOI filed so that you can begin accepting contributions so that you will be able to pay these people back, right? So I don't see a risk of a campaign, you know, piling up tens or twenties of thousands of dollars in expenses before filing a DOI. There's not really anything to be gained from that. But as a practical matter, we all know campaigns do not spring forward full grown from the ground, right? People talk to vendors. They talk to someone about acquiring a domain name. They talk to someone about what their logo is going to look like. And to the point that you made, Commissioner Watts, it may be that those vendors then bill them for those services later. And if the campaign is wise, it's going to have filed a DOI as soon as it can so that it can begin raising money to support its campaign. What is interesting here is there seems to be this effort to dig in and find something, some activity by this particular campaign that can be pointed out as being a potential violation. So I wanted to direct your attention, because you all have been asking about expenditures and when they're made. So the Commission's rules provide that expenditures are not made until an invoice is paid. And I'm specifically referencing Rule 189-3-.05. There was actually a repeal of Rule 189-3-.03 last year because the Commission recognized that inadvertent requirement of accrual accounting is beyond the scope and powers conferred on the Commission by the Act. So the repeal of that rule and the plain language of Rule 189-3.05 shows that campaigns are being told that an expenditure is reported during the time period in which the reimbursement is made, rather than when the original expense may have been incurred.
When you say reimbursement, that the term reimbursement there is that you paid the vendor, not that you reimburse your campaign. Right?
Correct.
Okay.
Correct. And as we've already covered, deeming expenditures to be contributions has some practical implications. We have an invoice from a law firm dated July 12th, which covered a 3-month time period. In the complaint, staff is treating the full amount of this invoice as a pre-DOI contribution. Less than half of the amount of this invoice was actually incurred prior to May 1st. And to the excellent point that Commissioner Watts made, campaigns don't have any control necessarily over when vendors are going to issue an invoice, and they definitely don't have any control over what in particular gets billed by counsel. I take issue with the assertion that there was any sort of quote-unquote malpractice, as Mr. Lane stated, by a campaign finance attorney, again, because there's nothing in our rules or in our statutes that says that a campaign or a candidate would not be allowed to consult with an attorney prior to filing a DOI. There's one other invoice that is at issue for purposes of the complaint besides the legal expense invoice, and that is G Strategies invoice. They were a campaign consultant. This is also an invoice that was sent and paid after the DOI was filed. So the question is the commission willing to take a deep dive on every initial CDR to determine whether a campaign, despite being invoiced and paying for something after filing a DOI, may have consulted with that vendor before filing the DOI? And why would the commission do that? There's no benefit to the public from requiring campaigns and vendors to jump through hoops like that. What there is, though, is a trap for campaigns that are, in fact, making good faith efforts to comply with the rules. I want to talk just briefly about some of the statements that were made today that I was hearing for the first time about the new filing system. Mr. Lane's reference to the new filing system, which will make it easy for people to simultaneously file their DOI and also deal with these potential expenses that they may have incurred immediately before the DOI. New filing system was not in place in 2017. So new filing system has nothing to do with the question of whether or not there was any issue here with this campaign. There was a question about the precedential value of consent orders. We've made a very, I think, diligent effort to dig in to see if we could find anything that would serve as precedent for what is happening here, what the staff is urging the commission to do here. Mr. Cusack's examples that I heard were all contributions. They were all about people accepting money from a donor pre-DOI. They were not about talking to your lawyer in April and filing your DOI in May.
Ms. Lewis, if I may.
Go ahead, Commissioner Barnum.
I'd like to just spend maybe a minute or so. What are your thoughts about the likelihood of a campaign being willing to enter into a consent decree with the commission if that consent decree later becomes precedential or becomes precedent going forward?
I would hope that campaigns would take into account the fact that what may seem to them to be the most cost-efficient way of dealing with a complaint could have a bigger impact than they are anticipating. And I appreciate your point that as far as the commission is concerned, when campaigns that are being criticized or that have had complaints filed against them enter into a consent order, sometimes they really are just doing that. Sometimes they really are just saying, well, let me pay this $500 fine and be done with this. Even if they believe that they have good faith reason for disputing the violation. So taking the position that these are precedential, if they are precedential, that's great. That needs to be publicized. People need to know that. And also, you need to be able to find these consent orders on your website. There are other states who have ethics commissions or boards similar to this one that have much more easily navigated websites. From a fairness standpoint, if you're going to hold people to the standard of knowing that this is a rule or this is an advisory opinion or this is a consent order, it needs to be easy to find that information. We searched, we couldn't find anything that looked like this. And, again, based upon Mr. Cusack's presentation today, I assume it's because it doesn't exist. But interviewed, that happened on a number of occasions. Staff was allowed to come in, campaign staff were allowed to come into the space with the candidate, and it was about efficiency. It's frankly no different than having a driver that drives the car so that the candidate can be in the back. If someone had seen the candidate at the Commerce Club, hosting a baby shower that had absolutely nothing to do with the campaign, and complained to the staff, complained to the commission about it, and staff investigated and found out that that was incorrect, the result would be an administrative dismissal. We're in an unusual position here because there is no impetus for making the assumption that this is a disallowable expense to begin with. In other words, there's no third party coming in and saying, well, that's not what she was using it for, I saw XYZ. There is
Let me know when it's
simply
updated, so tell her.
a presumption, which does not appear to arise from any rule that we've seen, a presumption that if you are using this space, then you must be deriving some personal benefit from it, and you are basically guilty until you are proven innocent. Now, I would add that, the commission has people make third-party complaints all the time, and staff is able to inquire and often administratively dismiss those types of claims, just by inquiring with the.
Those are paid for with campaign funds. That's lawful and we don't publish.
Okay. All right, Secretary Mike.
Well, to Commissioner Thompson's point, maybe they knew they shouldn't be disclosing in his membership dues.
It's fine.
Is that the case?
No, that's not what I said, though. I didn't say.
Well, I wasn't saying you said that, but I was picking up on your point.
But if as they put on there, they put a campaign event expense, and I think that's kind of what they use about campaign event. If they only used it for a campaign event, then that's not, being dishonest. If they never used it for personal use, even if it's a membership did. That's where I think we're in the weeds.
Okay. Commissioner Barton.
Sure. Mr. Cusack, Ms. Lewis raised an interesting point. I'd like you to respond to it if you can. I read it was either the advisory opinion or someplace else, the proposed advisory opinion, that the staff's position is that membership dues or fees at the Delta Sky Club, and let's just talk about the Sky Club, but I think it would apply to the Commerce Club as well, that an ad hoc day-to-day fee paid would be okay if they needed meeting space. And go ahead.
And that's very fact specific, because then you have to come back and tie it into how the campaign brought you there that day. So, are you getting what I'm saying? Like, if you have a campaign meeting via Zoom that day, okay, maybe that's an okay expenditure, but it's extremely fact specific for that day.
Right. So, and I get that. And I think what we've been talking about today are extremely fact specific scenarios. What I'm trying to get an understanding of is, what is the staff's distinction between an ad hoc day-to-day admission fee that theoretically could be utilized more than 300 or 400 times, or 300 times in a year, not 400, more than 300 times in a year, okay, for the purposes of having meetings, versus a yearly fee for purposes of having meetings.
Commissioner, the distinction being that when you pay the yearly fee, personal benefits inure to you. So, for example, if I could do just a day membership of the Brookstone Country Club, and then I throw my campaign launch party there, then I've not gotten a personal benefit and the personal benefit would be like, if I paid for the yearly membership, and I have my lunch in there, that's fine. But then Sunday when I'm leaving St. James, I take my family to the buffet. There's no campaign business at all on that Sunday brunch with the wife and the kid.
But don't those personal benefits inure to the campaign or to the individual every time they pay the fee and go in there?
No, because the day pass is tied directly to your campaign function.
No, I get that,
Sorry.
but I'm understanding the commission's argument that there are benefits
Correct.
that will be passed to or inure to an individual by going into that club.
Correct.
Those benefits are available whether they're paid on the yearly basis or on a daily basis.
That is correct, and we can't separate every possible way that you abuse campaign funds for personal use as long as it's for a campaign, like related to a campaign.
Right.
For example, if you're traveling and you go to New York for a fundraiser and you choose to stay at the Royal Suite at the Waldorf, that's a legitimate campaign expense. Now, it's not a good use of your campaign funds, but we don't regulate, is it a good use? We use it as a legitimate use. And as far as, like, we're not just making this from whole cloth either. There's an advisory opinion from 2014-03 in which Cobb County Superior Court judges said, we would like to purchase a security system because we're judges and we tip people off and they don't come kill us. Can we pay for that? And the commission said, yes, but. Yes, you can pay for it if you rent the security system or the security service, but you cannot pay for it even though it's cheaper just to buy it, because the purchasing of that security system constitutes a capital improvement to your home, which is a conversion under 21.533C. It's impermissible. So, and I'm sympathetic to the, well, why can't I just buy the cheaper yearly membership? Well, it's not allowed the way Georgia law is written, but.
Yeah, I'm not really focused on the most cost-effective way to go about it. I'm really focused on trying to understand the staff's distinction between benefits that would be inured to an individual on a daily basis versus benefits that would inure to the individual on a yearly basis.
And I think we would be able to make a very cogent argument, like going to the country club. I pay for the day pass, I hold my luncheon, but then I stay and I play tennis and around golf and I bring the family for dinner and all my supporters are gone. I have converted a good portion of that day pass into personal use. Now I think we probably have to we probably have to look at how many hours were you there, and then apportion out the day pass of X number of dollars was personal, X number of dollars was legitimate.
Right.
I mean,
right. No, so I think we're in agreement that in both instances, access to the club can be abused.
Correct.
Okay, which takes me back to my question, I believe Commissioner Thompson's question, which is, and we don't have any evidence today that in this particular case, the Abrams campaign access to either the Commerce Club or the Delta Sky Club was in fact abused. Am I stating that inaccurately?
I don't believe so.
All right. And Commissioner Watts, anything?
No.
Anything from anybody else? No. All right. I'm going to make a motion so we can try to put this forward one way or another. As I said, it's my position that we have to be mindful of allowing campaigns to use campaign expenses for membership dues. The Federal Election Commission has found that it's not qualified as an ordinary expense. So given that, I will make the motion that there is a violation of the Campaign Finance Act for use of campaign funds for purchase of membership dues in the Commerce Club and Delta Sky Miles Club. All right, motion may fail for a second. Can I get a second? Hearing none, we will open the floor if there's another motion. Is anyone going to make a motion one way or another? Otherwise, we're going to have to.
Mr. Chairman, I'll make a motion that we dismiss count one of the complaint with respect to membership expenses and fees and find that probable cause does not exist.
Okay, we've got a motion. Do we have a second?
Second.
We've got a motion and a second. Any discussion? All right, Commissioner Cranville.
I do, and I was waiting for the second for the discussion because procedurally, I think, and I know that I'm not trying to be a stickler to this, but I'm not sure that it would require any action.
Mm-hmm.
I mean, because I think that I don't think that you have to actually have a motion to not find reasonable grounds. I think that you either have a motion to find reasonable grounds or you don't. And I think as to that one count, since we didn't have a second on that motion, I think that.
So staff, what do you think on that?
Well, I agree with Commissioner Cranville, so I will withdraw my motion.
I'm curious.
We may have to, I want to see what.
Procedurally, I'm curious, because I don't know what we've done historically.
I'll temporarily withdraw my withdrawal. So
If we're going historically by precedent, the commission historically by precedent has either made a finding to find probable cause or not to find probable cause when you find in the negative. It by operation comes back to the staff to reevaluate, can you get more evidence, can you charge it differently, or should you just kill it? Dismiss it, better word choice.
And if I may, that's sort of my point on this is that, I mean, you said that there isn't really a double jeopardy
It's not.
that would apply in any way in this context. But, you know, it's almost like if you found there was no probable cause, that they wouldn't be able to go back in and reopen and continue an investigation.
that's kind of where I would.
But we have a subpoena out there that we're still dealing with that hasn't been possibly fully responded to, due to everything in Fulton County or, coming out.
Ms. Lewis, go ahead.
I just thought I might be able to be of some assistance. 189-2-.03, subsection 6 states at the end, if the commission finds no reasonable grounds to believe a violation has occurred, the complaint shall be dismissed, subject to being reopened upon discovery of additional evidence or relevant material. So I just thought that might help to answer Commissioner Kreinvold's question.
Great, thank you.
Give me that one more time.
189-2-.03, subsection 6.
And actually, so if I may, Mr. Chairman, I'm gonna stay with my motion, and that we find that no probable cause exists and dismiss that count.
Okay, well, we got the pending motion, we got discussion, so I get the consideration for the commission is if you provide the commission staff additional time to get answers to subpoenas, or whether we find that there's no reasonable grounds.
And I want to make clear, I don't believe that there is reasonable grounds. I don't believe that there is any reason to go back and find more evidence. I'm going to dismiss the count.
Well, Commissioners, I don't mean to be a flying the ointment, but since Commissioner Barman withdrew and then renewed his motion, if someone would second it, if they believe, just so there's no one complains about it later.
So we've got a pending motion, we've got a second from Commissioner Thompson.
There we go.
And so now we will open the floor for discussion. Did you hit Commissioner Cranville?
Yeah. And again, I'm reading the rule now, and it says, if you find no reasonable grounds, it shall be dismissed, subject to it being reopened upon discovery of additional evidence or relevant material. So I think it's not a motion to dismiss, it's a motion to not find reasonable grounds. From my reading.
Is that what the motion was? I think
he changed it, because he started saying dismiss.
Yeah,
I don't think there's a we recently hit this issue. There's no pending motion to dismiss before the commission. So I think it's just
right.
motion not to find reasonable grounds.
And just so Commissioners, for the Oxendine case, you did do a split vote where you found reasonable grounds on some, but not on others.
Sure.
And then what we did at that point is we didn't bring back to you the not reasonable grounds ones, but we forwarded on to OSA only those grounds we found reasonable grounds on. The other ones,
Yeah, understood. And it sounds like in the rules, there is not a mechanism available to completely dismiss a count. This would be my preference, because I think we wasted enough public resources on this count. My preference would be to completely dismiss this count. But if that procedure is not available, then
Yeah, so we got a motion to find no reasonable grounds, right? And then we've got a second. So now we've got discussion on that motion. Okay, any further discussion? Hearing none, I'll call the question. All in favor, say aye. Aye. All opposed, say aye. Aye. Okay, so motion carries. No reasonable grounds to believe Campaign Finance Act has been violated as to the lack of ordinary expense for membership and it carries 4-1 with Chairman Evans as the sole opposition. Okay, so next we've got took contributions before the DOI was filed. And this was the in-kind contributions. And to me, this hinges on whether or not the May 1st filing qualifies as a technical defect. So if you guys, I'd love to hear from each of you guys to speak on that issue, whether, because it was incontrovertibly filed on May 1. The DOI was filed on May 2nd. So the question is whether there's a technical defect.
Commissioners, when you go to the technical defect definition contained within the rules, it states that it's accounting errors. It's, 2 + 2 is 6, or you misplace a decimal. It's not the failure to disclose something. It's not the failure to disclose what the purpose is. It's not the failure to disclose who the payee was. I do find it mildly disingenuous that, well, as for the technical defect, if you also look at 2157.1, which is the technical defect statute within the code, commission staff makes that determination whether it's a technical defect and then provides what's known as a technical defect notice. Then the campaign has 45 days to correct that technical defect. If they don't, then that technical defect converts into a violation of the Campaign Finance Act for failure to correct it. It is not the ability of a campaign to show up and say, no, that was a technical defect, we invoke 21.5.71. That's just not how the law operates. So I appreciate them claiming it's a technical defect, but it's a little hard to claim it's a technical defect when you don't really change it until after you've been sued and go, wait, never mind, we were just kidding. We really meant it was on this day, not that day.
All right, Commissioner Granville?
Well, you kind of just got to the point there at the very end. I mean, what if it was a mistake on their part? That it actually was something that they received on the 2nd and not the 1st. It's a scrivener's error on a date.
And if they had the ability to prove, because they're saying this is a transfer of documents, data, what have you. Because if I remember correctly, they were like a call list, a donor list, furniture. You're going to have proof of when that was received. I would assume the data transfer occurred probably by email or FTP transfer. That's going to have a date associated with it. It's just really hard at the probable cause stage for commission staff to have someone come to say, promise and trust us. Mr. Fuller used to always say it's not the reasonable Boy Scout promise standard. And that's frankly all we've gotten.
Didn't Ms. Lewis said just these contributions, I believe your statement was that these contributions occurred
On May 2nd.
on May 2nd.
On May 2nd, but when the staff was putting together the report, they mistakenly believed that the DOI date was May 1st.
Okay.
And so they put May 1st on the form, but the actual contributions occurred on May 2nd after the DOI was filed.
Okay, so I want to make sure. So the staff, the DOI date, the date that the form was completed was May 1st. No?
The date that the DOI form was completed was May 2nd.
May 2nd.
Was May 2nd.
Right. Staff believed that the contributions occurred on what day?
They occurred on May 2nd.
Okay.
But when someone was preparing the CCDR,
Okay.
they mistakenly believed that the DOI had been filed on May 1st, and so that's the date that they put as the date that the transfer was received, but it was not until May 2nd.
So I want to make sure I'm clear. So staff believed that the
Campaign staff, just to be
campaign staff,
clear.
yes, I'm sorry, thank you for that clarification.
Wasn't you, Joyce? Is that what you're saying?
The Abrams for Governor campaign staff believed that the contributions occurred on May 2nd.
The contributions occurred on May 2nd.
Okay.
But when the report was being prepared, there was a mistaken designation of May 1st.
Understood.
On the form.
Okay. And so is the controversy here, the allegation is that the date of the contributions was mistakenly identified?
That the position of the campaign is that when staff was completing the form, they should have put May 2nd and they mistakenly put May 1st. It is a scrivener's error.
Thank you. Mr. Lane,
Yes, sir.
help us understand
Sure.
staff's position in light of Ms. Lewis's explanation.
You have a dispute of fact, Commissioner, and we're at a probable cause stage. You're not determining guilt or innocence or which one is correct. They're promising without support. There's no affidavit, there's no testimony from this person, there's no email transfer log, there's no data, for lack of a term, log showing when this occurred. We have disclosures that say it happened on this date. They're saying it happened on this date. That's a material dispute of fact. It should go to a trial.
Can't y'all talk and figure that out?
My understanding is that attempt has been made and has been unsuccessful.
I'm not aware of any such attempt, just for the record.
Ms. Lewis, you're here as the campaign lawyer today. Are you able to make a representation that the campaign and the staff, the commission staff can talk and figure that out?
We're happy to work with them to figure that out and to provide whatever they need. But they have not approached us, notwithstanding what Mr. Lane just said, they've not engaged with us on this issue.
Mr. Lane,
Again, before I walked in here today, I did not even know that this was still an issue, given that the technical defect had already been corrected.
all right, so Mr. Lane, we're here in a public forum. Ms. Lewis has just made a representation on behalf of the campaign. Is that good enough for you?
Frankly, we've always been happy to try and work with opposing parties. I think this commission has seen over at least the past 7 years when opposing parties come and they bring evidence that they have not violated the law, the people quickest to dismiss claims have been commission staff.
Okay, perfect. But it sounds like we have an agreement that we can figure that out, whether or not it was in fact a technical error.
Oh, well, I think that's the issue before. I mean, you guys, this is between you, but are you, Commissioner Barton, are you suggesting they're gonna work out whether there was a technical defect?
Well, here's what I'm hearing, Mr. Commissioner, is that the commission staff is saying it was not a technical error. Ms. Lewis is saying that it was. And when I asked commission staff, given her representation, Mr. Lane's response was, well, there's no evidence of a technical error. They're just making that assertion. And what I'm saying is, if it was a technical error and the staff can demonstrate that, then, I mean.
And I hope I don't make everyone groan by this, but what the commission has done as a precedent is generally, when there is this dispute and there's this representation of, we promise we can show it's really not a violation, the commission will find probable cause, because within our own procedural rules, once you find probable cause, the case is stayed for 45 days for the parties to continue going back and forth, trying to determine, is there a violation, is there an excuse, is there a defense? And then that's before it goes off to the Office of State Administrative Hearings for a final hearing.
Is that
All right, hold on, we've got to let other people speak.
But that is something the commission has done as practice. for-
Commissioner Wise.
Well, so, I mean, don't we just now decide? And, I mean, I guess to the commissioner's point, if they want to settle, fine.
No, well, typically what we've done is we find probable cause, and then the parties work it out and determine whether they can reach a settlement. All right, Commissioner Granville.
The one thing that I did have a problem with, and that I continue to struggle with a little bit on this issue, is, early on in your presentation, you were suggesting at least that the date that the services were provided could have been later, but then they were just backdated to the beginning for whenever the campaign began. It was almost like that May 2nd date came out of thin air. Well, it didn't come out of thin air, but it was generated based on the filing date of the DOI. Had the DOI been filed on May the 1st, that would have been the date that these services would have been provided. Had the DOI been filed in March, that it would have been backdated to those. And so I am struggling a little bit on, just accepting, again, I'm not questioning your word by any means, but I'm just, it seems like it wasn't a very definitive statement to say that, okay, these services were definitely provided on the 2nd, and we meant to say they were on the 2nd, but they were inadvertently put on the 1st.
And again, the part of the problem is I was not made aware we were not made aware prior to walking in here today that the correction of the technical defect had not been accepted or was being contested by staff. No one contacted us and said, no, this is not correction of a technical defect, and this is still an issue that's going to be live. So while I understood and knew that the services or the file transfer had happened post DOI, I did not have an exact date because I didn't realize that this was going to be actually in controversy today. My colleague, in communication with our client while I was presenting, received the confirmation of the date, which was May 2nd. And, again, if we had been contacted in advance of this and told there's a problem with you doing this, we don't believe you, you're not allowed to amend the technical defect in this way, this is not a technical defect, if any of that had happened, then I would have been better prepared on that point. Unfortunately, none of that happened prior to me walking into this room today.
Commissioner Watts.
Is it in the complaint? Is the allegation still in the complaint?
Yes, it is.
Okay. Any further discussion? Anyone want to make a motion? Commissioner Watts, you want to make a motion?
Well, I'm trying to think of how to word this, so. I will make a motion to find probable cause that the expenses, disclosed by campaign as incurred on May 1st, were incurred prior to the filing of a DOI.
Is that the in-kind contributions, not the expenses?
Yeah, that's right.
I'm sorry, I'm not trying to mix the legal services, because I obviously have an issue with that, but
So this is the in-kind contributions. Is what we're talking
That's right.
the ones that were self-disclosed back to May 1st, yeah. Right, that's what we're talking
Okay, so
about.
I'll repeat, I'm going to paraphrase to make sure I'm right. Your motion is that reasonable grounds exist that the Campaign Finance Act was violated because in-kind contributions were given prior to the filing of a declaration of intent.
Correct.
Okay. We've got a motion. Do we have a second? I will second the motion. We have a motion and a second. We'll open it for discussion. Any discussion?
Yes,
Commissioner
I
Barton.
just want to make sure I have clarity on the motion, that the in-kind contributions, the motion is that the in-kind contributions were given prior to the May 1st disclosure,
It's May 2nd.
May 2nd disclosure.
The May 2nd declaration of intent filing.
Right, that the in-kind contributions were given prior to that. And that motion is in light of what we heard today in Ms. Lewis's representation that those services were given after the fact. So what we're really coming down to in the motion would be based upon a credibility determination of what we're hearing today?
Well, we don't make credibility. This is probable cause. So
Well, I'm trying to understand the basis of the motion, yeah.
Commissioner Watts.
Yeah, so again, from my perspective, this was self-disclosed. It was before the DOI. And so if there is evidence to the contrary, that this was a technical defect, I'm more than happy for the commission staff to go work this out however they need to. But I'm saying based on the self-disclosure that these things, in-kind contributions, occurred on May 1st, based on what I've heard today, that's the motion. That there's probable cause to believe that they were incurred before the filing of the DOI.
Commissioner Thompson.
If that's unsubstantiated later, I'm all ears.
Okay, thank you.
I'm on the same page. I mean, since it was self-disclosed that it was received before the DOI, which nobody's disputing, It comes down to whether it's a technical. I find it a little aggressive that we have to find probable cause just to try to get this worked out, but it seems by the facts, it's probably what we're going to have to do.
Okay. All right, any further discussion? Hearing none, I'll call the question. All in favor, say aye. Aye. All opposed, say aye.
Aye.
Okay, motion carries 4-1 with Commissioner Barnum as the sole opposition. All right, so next, we've got took expenditures before the DOI. And my breakdown of this, and we want to hear from both of you on this one, is the Campaign Finance Act only says contributions are barred prior to the filing of a DOI. There is an AO, which is in 2020, which is after this took place, which says that expenditures are also included. I want to hear more from you guys on this narrow issue, just about whether expenditures are barred prior to the filing of a DOI, and what your legal support is for that.
Commissioners, the legal support is the way that the legislature has drafted both 21.530 subsection G, which states that no campaign may accept campaign contributions prior to the filing or declaration of intention to accept campaign contributions. It goes on to say some other things, but that's the gist of it. When you go to the definition of what is a campaign contribution, which is contained at 21.5.3 subsection C, a contribution is a gift, a subscription, a membership, a loan, forgiveness of debt, advance or deposit of money, or anything of value transferred or conveyed for the purpose of influencing the nomination for election or election of any person to office. With that expansive definition of a contribution, it becomes almost impossible, in fact, it does become impossible to make an expenditure prior to DOI because you have nothing to expend. You are not permitted to take a contribution before DOI. Expenditure is defined in 21.5.3 subsection 12. It's defined as the purchase, payment, distribution, loan, advance, deposit, or any transfer of money or anything of value made for the purpose of influencing the nomination for election or election of any person. I don't see how you can make a legal distinction that an expenditure, which doesn't spring forth from the ground, can occur until you've taken a contribution. The legislature didn't say you can't make an expenditure because there would be nothing to expend. The way they have defined contribution, you can't take anything before your DOI if you're a candidate. So how would you, by operation of law, make an expenditure of something that doesn't exist, that you lawfully cannot have in your possession? That's just a disconnect I can't make.
Commissioner Wise?
You're saying you can't make an expenditure, there is no way to make an expenditure prior to filing the DOI?
Correct. What are you expending?
Well,
if you can't take a contribution, and a contribution is anything conveyed of value, what are you expending? If you can't take anything of value, what in the world are you expending for the campaign?
But to use your words, that's not what the law says.
That is what the law says. The law says you cannot take a contribution prior to DOI.
But the law doesn't equate contributions and expenditures.
Correct, but how do you make an expenditure without first taking a contribution?
Well, I'm saying that may very well be a gap in the law that needs to be closed. But, I mean, Ms. Lewis made the point that the form talks about declaration of intent to take contributions.
Correct.
Right? And contributions and expenditures and indebtedness are made on separate pages of the form, right? Contributions are listed in one place, expenditures are listed in another place.
Correct.
Indebtedness, right?
Correct.
So.
And I agree with Mr. Watts, there's an error in the complaint where it says expenditure.
Okay.
It should read, as all the other complaints who deal with this say, impermissibly accepted contribution prior to the filing of declaration of intention to accept campaign contributions, a violation of 21.530 subsection G. That is the standard stock language for all of these violations.
so, if I may, just to round out the expenditure question, there's no requirement under the law that I see, or even in the definition, that an expenditure has to, be dollar for dollar from a contribution, right?
It must come from somewhere.
Well, yeah, it could come from me. I mean, I can just pay for something.
And the Supreme Court has said that your own personal funds used towards your campaign are contributions, subject to disclosure and regulation. That's in Taylor versus Common Cause of Georgia, and it's a 1979 case.
So then Commissioner Watts' payment would be a contribution that he has to disclose.
Correct, and he wouldn't be permitted to make it until he filed a DOI. And the only reason I know that is the commission punished Judge Melanie Lethbridge in 2015 for this very issue. She expended $4,600 and something, forgive me for not having it exactly.
You remember a lot more than I thought you would.
But $4,600 and something to her campaign consultant prior to the filing of DOI, and it was her own personal money. And the commission found that to be a violation of 21-530 subsection G because she made a contribution, which was her own money, prior to the filing of her DOI. And if I remember correctly, the fine was over $500. The commission took pity on her because it was her own money, not someone else's.
All right, hold on. Commissioner Thompson.
Which expenditures are we saying that they made? Because are we meeting these in with the attorney fees and the consulting that was paid later on?
This one is, it's a good question, Commissioner
Correct.
Thompson. This is not the attorney's fees one. This is the Georgia Next, right? No, not the Georgia Next. Sorry. It's the travel expenses. And is that right?
This is the legal fees.
No, this is not the legal fees.
The legal fees pre-DOI.
Yeah,
Yeah.
Okay.
Legal fees came twice.
That's right.
Yeah.
That's right.
Legal fees pre-DOI, there's legal fees and were they disclosed or not. The legal fees are included in those.
That's right.
The April 5th to May 1st.
Yeah.
So they actually didn't expend it though. They incurred it at the time. And this is why I was against taking away the debt incurred in the rules back in September of 2020.
Well, and here's the thing, Commissioner, I forgot which commissioner brought it up, but I wrote it down. You talked about the acceptance of services. That's what you're really looking at before DOI. You're not looking, when did they put it on their disclosure? Did they get it on the right disclosure period? Did they get it late? You're looking at when did they get the good or service? Because when you get that good or service, it is a campaign contribution with the way that the law is drafted and the way our rules are interpreted and enforced. When you get that good or service, it inures to the campaign. And using this as an example, the campaign didn't say, oh, well, we didn't get billed for it, so I'm not going to use the incorporation they drafted for a year. They got the good and benefit. So that's why that rule, which Ms. Lewis cited to 189 3.05 states, when you do an advancement of goods or services or credit, the contribution limits apply. Because if you were just going to say, well, if no one pays for an expenditure.
To me, there's a distinction. We've got the legal fees, and that's one. And I actually put it in the fourth bucket. We would have to do a dual analysis. And then we've got the taxi service, the Delta flight, the Hilton hotel, the Uber. So, and to me, if those were incurred in early and mid-April, in furtherance of the campaign.
But I think, and the difficulty, or maybe the disagreement we're having, or the disagreement between the staff, attorneys, and the campaign is when an expenditure becomes an expenditure.
Correct.
Okay? Mr. Lewis's argument is that it becomes an expenditure when you get a bill and pay it. And the staff attorney's position is it becomes an expenditure when the services are rendered.
Correct.
Irrespective of when a bill might come.
Correct.
Now, I believe Commissioner Watts asked in a hypothetical, so if a copy service or a web designer or printing service decided, you know what, we really like your campaign, we're gonna offer those pro bono, and there's never a bill, I mean, they can do that, right?
For professional service, yes, sir, because it's not a physical item.
Right. Okay.
Different story for a sign or something.
Right, for professional services, right?
Correct.
Is that not what we're talking about in this case?
That's correct.
Well, I'm trying to I think it's best to separate them.
To the chairman's point on that, now I see why he was saying that. the Uber, that would have been paid beforehand. So that was clearly an expenditure.
Yeah, I mean,
The taxi was an expenditure. There's not a delayed bill that's gonna come with those items. The only one that's gonna have the delayed bill is gonna be the legal fees. That's why that does need to be carved out separately, because I have a different feeling about
I have
that.
a very different
If-
feeling.
yeah, I mean.
If I may,
Sure, Ms.
Commissioner
Lozano.
Primal, to answer that point that you just made, the expenses that are being referenced are actually vendor expenses that were being reimbursed. So again, this is not the campaign or the candidate paying for an Uber or what have you. They received an invoice from a vendor after the DOI was filed, and they paid that invoice after the DOI was filed.
But wouldn't that be included within the invoice? I mean, it's like with attorneys, if you look at this invoice, there is travel expenses on that invoice. So whenever the vendor sends the invoice and says, hey, this is the amount I'm owed, here's our travel, you just cut a check for here's 20,000, we had 1,000 was travel. You just say, here's 20,000, and you allocate the 1,000.
Correct, so the campaign is reporting the expenditure in both instances. The campaign is reporting the expenditure when the campaign pays the invoice.
Yeah,
If
but
the
you didn't do that
campaign
with legal though, right?
if the campaign receives the invoice after filing the DOI and pays the invoice after filing the DOI, there is no issue of a violation there. Again, the language of the statute, the language of the rule, the language of the forms, all says declaration of intention to accept contribution. There's no evidence that any contribution was made. Again, the complaint itself alleges that these were expenditures that were made pre-DOI. There is no prohibition against making an expenditure pre-DOI, and as a matter of fact, an expenditure was not made until after the DOI was filed, which was after the invoice was sent to the campaign. Invoices were sent to the campaign.
And I appreciate you, because if you corrected me then, so these expenditures, the payments that were actually made for the Uber, the taxi, and everything else, those were all made after the DOI.
Correct.
Okay.
And I'm sorry, one more question, if I can. What was the vendor, what was this particular vendor doing, the one that was charging for the Uber and taxi?
They're a campaign consultant.
And they were, okay.
Yeah, but I do think there's two. We've got the legal thing and we've got this. Most of the time, and the way the lawyers handle this, and most vendors handle it, is you send an invoice and it's got travel. And you pay the overall invoice, and here that's what happened. And you'll pay $20,000 or the $26,000, and that includes the travel. It would be somewhat unusual to have a vendor that says, here's my fee, also directly reimburse me. My biggest snag with this one is the 118-3-.05 is just clear on reimbursements, that they shall be reported as an expenditure on the campaign disclosure report for the time period in which the reimbursement is made. Now, for you, does that mean when the reimbursement is actually incurred, or does that mean when it's paid?
Correct. 189.305 was designed for when you have instances where I'm running for governor and I use my American Express card to pay for expenses. And then I get the American Express bill, I'm required to then show that the expenditure occurred when I made the American Express bill, but when you fill out your disclosure, the rule requires that you list all of the transactions that are actually related to that amount. So it'll say $10,000 to American Express, $5,000 to John Signs, $2,000 to Commerce Club, $1,000 to Brookstone Country Club, and it'll have the respective dates those sub-transactions were made. That is the point of 189-3.05. I think we still get back to, and forgive me for harping on it, you can't make an expenditure if you haven't received a contribution. That's a physical impossibility.
I'm going to go back. I'm going to repeat the language that Chairman Evans read. And it says, it must be itemized and shall be reported as an expenditure on the campaign contribution disclosure report for the time period in which the reimbursement is made. Not when the expense is incurred, when the reimbursement is made. I mean, and I'm hearing that it was disclosed on the report for the period of time once it was, the reimbursement or the payment was made.
And correct, Commissioner, that's a rule governing when you put it on your disclosure statement. It's not a rule governing when you can start taking contributions and making expenditures.
Yeah, I understand, but you keep calling it a contribution, and I think there's just a disagreement there.
But by the same token, that rule is controlling when you put it on your CCDR, when you report it. It's an accounting rule.
Okay?
So I don't think it's a get out of jail free card that I've made expenditures, because if you're making expenditures, you got a contribution from it somewhere. I know there's a disagreement, I'm having a real bad disconnect there.
I think I understand your position.
All right, any other discussion?
Motion, Mr. Chairman.
I will make a motion that, my motion is going to be limited to these expenses that are made before. I don't know how we differentiate between the legal and the G strategies and the taxi service.
Well, I was actually gonna make a different motion, Mr. Chairman, but if you wanna make that one, go ahead.
Now, go ahead, Mr. Commissioner Barton.
Yeah, I was going to move that we find no probable cause that the expenditures were incurred, or that the expenditures were incurred before the DOI, and I forget the exact date of the DOI.
May 2nd.
Before the May 2nd DOI. That's my motion.
And is that for all the expenditures?
Yes, because I don't think we can get into, and should get into a parsing out of each expenditure unless there's specific evidence, and I haven't heard specific evidence that expenditure 1, 2, and 3 were incurred before the DOI, and expenditures 4, 5, and 6 were incurred after. I mean, the complaint is that all of the expenditures are being lumped together, and if I'm not understanding the staff attorney's position, let me know.
Yes, in regards to the legal fees, the ones prior to the DOI are separated. Those are the only ones prior to the DOI which we are alleging were improper. We use the total value because we don't know what the actual value is, so better to overshoot the value than undershoot it. In regards to the G Strategies ones, those are for expenditures that are made or being reimbursed prior to the DOI where no campaign existed.
Okay, and I apologize, Mr. Cusack, I probably wasn't clear. I thought we were putting these Uber and other types of expenses in one bucket, and the legal fees we're putting in a different bucket, which was even before.
Well, yeah, the legal fees.
Yeah.
Right.
I was trying to just separate them.
Right, and that's what my motion was based upon what I believe Mr. Chairman Evans' effort to separate them out.
Well, we have a motion. Do we have a second?
Well, I'm still unclear what the motion is and what it's encompassing.
Okay, that's fair. That's fair.
Yeah.
So,
Go ahead, you can provide.
I think we've got something, I'm sorry. My understanding is that the expenses, there's a claim that there were expenses incurred prior to the filing of the May 2nd declaration of intent. My motion is to find no probable cause to support the claim that there were expenses incurred prior to the May 2nd DOI and not disclosed, that there were expenses that were incurred and not disclosed on the May 2nd DOI.
Okay. So we've got a motion. Do we have a second? All right. Hearing none. My thought on it is, I think there's a factual issue on these about whether they were incurred and disclosed for reimbursement before or after May 2nd. Typically, vendors are going to include these on the invoice. I don't know if that happened here, didn't happen here. I don't know what these were incurred for, and I think there's a factual issue to that extent. Given that, I will make the motion that for these, the non-lawyer expenses, and that is the G Strategies, Alex Taxi Service, Delta, Hilton, Uber, that there's reasonable grounds to believe those were incurred, qualify as expenditures prior to the filing of the DOI on May 2nd, 2017, and therefore is a violation of the Campaign Finance Act. We gotta have a second
Oh, I'm
before
sorry,
we
go ahead.
before we can get discussion. Unless you want to amend the motion.
I didn't answer my question.
What's that?
I said I didn't answer my question.
Okay, go ahead.
All right, so is there evidence that,
Well, why don't you just second it?
I think we need to.
We got it, it's a pending motion.
We need to
So
have a
if you
second.
second it,
go
then,
ahead. I'm not gonna second.
okay, that's fair.
Mr. Chairman, I think the motion.
All right,
passed.
motion dies for lack of a second then. So we've got we've ran into this recently, so we've got a motion to find reasonable grounds felt, motion, for reasonable grounds felt, so now we've got either, do we table it? No. We make no finding, which is, what's the effect of no finding?
Commissioners generally like
Commissioner Cranville, go ahead.
The problem that I had was with the way that the motion was worded again. I mean, I know this is difficult because we're trying to parse things out, but I'm going to make another motion.
Go ahead.
And I'm making a motion as to all of these expenditures, including the legal expenditures, along with the Uber, along with the Alex Taxi, the Hilton Hotels, and the Delta Airlines. I'm going to move that we find that there are no reasonable grounds to find that the Campaign Finance Act was violated due to a failure to disclose these various items.
Second.
Okay, we got a motion and a second. Executive Secretary Monty?
Due to a failure to disclose or due to them not occurring before the DOI? Because they were disclosed.
Yes, due to them not occurring before the DOI.
Okay, any other discussions? Mike,
I've got one question. Yeah.
go ahead.
Is it true that for the non-legal services, the other services, vendor services, were those paid by the campaign after the DOI?
They were paid after the DOI for services that occurred before the DOI.
Got it, thank you.
Okay, any other discussion? But my only comment is that I think the legal fees should not qualify as an expenditure or contribution, given that the invoice incontrovertibly was not given until after May 2nd. I think that the ones before, there's an issue of fact about whether these clearly move forward the campaign, and further discovery should be done to investigate that. And so given that, I can't support that motion, but that's my only issue of discussion. Anything else?
One more question. Again, for the non-legal services, the other ones that the chairman just mentioned, was that invoiced to the campaign prior to the DOI?
I have no idea. Those were self-disclosed disclosures that showed that reimbursement for what was, I guess, billed to the campaign prior to the DOI.
Ms. Lewis, you know the answer to that question?
They were invoiced after the DOI.
Commissioner, just by way of clarification, before, just for your consideration, if you adopt the standard that an expenditure can occur and it's not a contribution, then you're also going to be impacting the maximum contribution limits contained in 21.541. Because a campaign could come and say, well, I didn't take a contribution. I just took $50,000 worth of expenditures from my supporter. And, well, it's not a contribution, and you only say I can't take beyond this amount in contributions. So it's just some food for thought.
Okay. Secretary Monty?
Yeah, and look, this isn't for me to decide, this is for this board to decide. But to be clear, adopting this ruling, and I want to make sure everyone's clear about this, is adopting a model where you can get all of the benefits of tens and 20s and 30s and 50s of thousands of dollars, wait several months, never have to disclose, and just backdate the billing. And if that's the will of the body, so be it, but that's the effect of what this would do.
If I may,
Sure, Ms. Lewis.
respectfully, these are all issues that could be worked out in an advisory opinion. What is in front of this commission right now is what the standard was and what the rules were at the time of these expenditures or these charges or these disclosures, which is 2017. So with all due respect to Mr. Lane, if he believes that there's some danger, he can certainly put that in front of this commission in an appropriate way and at an appropriate time.
Very good, thank you.
Thanks.
And with all due respect to Ms. Lewis, the appropriate time to address precedent under our law is now, because that is when we make precedent. Your advisory opinion doesn't overturn the precedent you would set today. So you just need to know, and the decision's yours, but you would have the effect of basically invalidating 21.541 and the maximum contribution limits. Because it doesn't state, thou shalt not take maximum expenditures in the amount of, and then for each office it gives a limit. It says contributions.
Mr. Chairman, call the question.
So.
I think that's my discretion, but I will do that assuming there's no other discussion. Does anyone have any other comment? Okay, hearing none, I'll call the question. All in favor, say aye.
Aye.
All opposed, say aye. Aye. All right, motion carries 4-1 with Chairman Evans as the sole opposition. Okay, time for a lunch break. I know that we have you guys here. We're gonna try to do a quick lunch break. I really need a little bit of food. Is that okay for you guys? Can you wait 15 minutes?
Mr. Chairman, I'm on the second case, and we were gonna ask for a continuance because we just got an amended set of complaint yesterday in the mail. So I was hoping that you could possibly take that up so I could be excused.
Well, it seems like you guys consent to a continuance.
We've recently become in contact with
I think that's it.
Do we have a consistent, do we set a date for a continuance? Just to the next meeting?
So I guess the only, there is one remaining issue, and that's whether the attorney's fees were not reported at all. Okay. I apologize to get everyone's hopes up. All right, so let's hit this last issue, and that is whether these expenditures were reported at all. This to me seems like a factual issue. We've got, it's the opinion of Ms. Lewis that they were ultimately disclosed. You guys say they weren't. The question is whether I'll let you speak. So that's effectively what the remaining issue. I mean, you tell me, Mr. Lane, if the complaint didn't say that they were late, and she says that they were reported, they were just late, how do you respond to that?
There's not.
I don't want to speak on your behalf, Ms. Lewis.
Well, just briefly, I did not say that they were late. They were timely reported when the expenditures were made, when the invoice payments were made. That was timely.
There's no such violation as failure to late disclose something. You either fail to disclose it or you don't.
Can I just ask for quick? I'm sorry. But if I'm understanding what you're saying, they were disclosed when they were paid. It's just that it wasn't all paid at once. It was almost like they were on a payment plan.
Correct.
Okay, so
And there's no rule against that, to my knowledge.
Okay.
Okay. So anything else from Mr. Lane, or about this issue?
No, sir.
All right, Secretary Motti?
You're absolutely right, this is factual. All I'll point out is Ms. Lewis is arguing that it was paid over time. She points to 2 disclosures. That number does not add up to the number that is in the billing receipt. That's the factual dispute. It's $1,000 or so off. We have no way of knowing whether that is the same or is not the same charge. We don't have access to that. So the commission just has to determine if there's probable cause or a reasonable belief to believe that we know those were definitely the same ones and there's no violation, potential violation or not. And that is the factual posture.
All right, Commissioner Thompson.
So just my question, Mr. Amano, to that, is that I believe it was stated that everything was reported. Is that not true? Not true. Okay, then I misunderstood. So we are saying that the evidence we have, there is an amount of money that is missing from the bill we have.
Actually, the amount of money that Ms. Lewis pointed to in the 2 disclosures is larger than the bill we're looking at. So I think that creates a reasonable possibility that a violation has occurred until we can really ferret out the receipts and look at what was what. But saying, hey, here are the 2 disclosures, they cover that, well, that's the 2 bills paid together, well, that's a different number than we were talking about before.
If I may.
Mr. Lewis, sure.
The allegation in paragraph 16 of the complaint is $24,599.91. I do not have the exact number in front of me. Mr. Sparks may. And I am very terrible at math. But we're talking about a difference of approximately $619.91. And my understanding, and again to the point that this was paid over time, is that could be attributable to interest on the outstanding invoice. Since
The law firm charges interest?
my law firm charges interest
Oh, good for you.
on late payments. This is not my law firm, obviously.
So is it your
this is
position-
Sandler Reed.
Is it your position that amount was only for the 24,000 and some odd number that we incurred?
$24,599.91, correct? That was the original invoice.
And plus interest.
That is my understanding.
So the amount that was actually paid was the additional $600 and some. So the reason that the numbers don't match up is because the interest is paid as well?
Pardon me, I'm receiving information from the client that there could also be other invoices mixed in with that, but the full amount of the invoice in question that was stated in the complaint was satisfied through these 2 payments in December of 2017 and in May of 2018.
And so, Ms. Lewis, I just want to make sure, because our concern, I'm sure the law firm's concern is that the invoice be satisfied. Our concern were those legal payments disclosed?
Yes, they were. They were timely disclosed within on the report, the very next report following the individual payments being made. And there's no basis to allege that this invoice was not paid.
Or disclosed?
Or disclosed.
Because I don't know that I'm that concerned about whether it was paid.
Correct, and I meant to make this point earlier. I mean, as people who are lawyers know that sometimes you send off an invoice and your client, takes off for one reason or another. So it's not an unusual circumstance for a payment for an attorney invoice to not match specifically the invoice amount.
Don't I know it?
Unfortunately. Unfortunate but true. So, thank you.
All right. Any further comments, discussion? Anyone want to make a motion? Commissioner Thompson?
I'll move to we find probable cause on this issue because nobody can demonstrate either way. The staff has done, their part to show that it does not look
like it's been satisfied. So for probable cause, I'll make that motion.
Okay, we got a motion, we got a second. Any discussion? Hearing none, I'll call the question. All in favor, say aye. Aye. All opposed?
No.
Okay, motion carries 4-1 with Commissioner Barnum as the opposition. All right.
Commissioners, if I may, just before you break for lunch, would y'all possibly consider tabling the advisory opinion?
All right, we may have to do that.
And the only reason I
I don't
ask,
know how we, I don't know how we.
Given that it's 2:30 and we've just gotten this far, I think it's
the
gonna be.
main reason I ask is I have a medical appointment in 45 minutes, I cannot reschedule,
Okay.
so.
Well,
So thank you.
all right, well, we'll,
I think substantively, what's been discussed today makes the advisory opinion, it needs to be rewritten.
It does.
I think that's right. So yes, I will make the motion to table let me get the number.
Advisory opinion 2004.
And I would also encourage the staff to revise it in accord with the findings today, and there may be additional revisions. Okay, but motion to table advisory opinion number 2020-4. If I could get a second.
Second.
Okay.
Before we vote,
Sure.
check with Ms. Lewis, just make sure, you know, under the 60-day rule, just make sure they don't, she doesn't have a problem with that. I know we've already passed it, but just.
Yeah, well, sure. Ms. Lewis, so Commissioner Cranfield said there is a statutory requirement for us to respond within 60 days. Are you okay with us tabling it to get it more in accord with the commission's findings today and for all the commissioners to be here to consider it?
Yes, I'm fine.
Okay, thank you.
Thank you, Commissioners. Thank you, Ms. Lewis.
All right, so call the question. All in favor, say aye. Aye. All opposed? All right. So next we got you guys it looks like there's consent between the commission staff and you for your continuance.
Okay.
So you'll be good to go. I don't think we have to make a motion on that, given you guys have consent.
Thank you.
But we appreciate both of you guys for coming today.
Appreciate it.
And I will, we'll do a recess. I don't think I have to make a motion. Okay. So I will move that we enter executive session to discuss personnel matters. Get a second. Okay. Any discussion? Hearing none, I'll call the question. All in favor, say aye. Aye.
2-8-32. Thank you.
Thank you for coming.
Thank you, Commissioners.
Well, it's probably just me.
Thank you. Take it, my pleasure.
I don't know if we're coming.
It's good to have this.
Okay, all right, well, at least it didn't take Doug's record until like 7.
So we got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor, say aye. Aye. All right, we've concluded executive session, and after conclusion of executive session, I will make a motion.
Sorry for that.
Yeah, go ahead.
Personnel matters to be added personnel.
I thought we did. Yeah, we got that, right?
We sent you a modified agenda where it's falling off. Sorry. Okay. Okay. All right.
You got us covered with the open records. And after executive session, I will make a motion that we increase the executive secretary David Amati's salary to $140,000. If I can get a second. I've got a motion and a second. All in favor, say aye. Aye. All opposed? Hearing none, the motion carries. Congratulations. So next on the agenda, we've got consent order, and we got Mr. Thomas, and that's 20-0086-C. And it looks like Mr. Cusack, that's you. Commissioner Watts, thank you.
Ms. Johnson?
Is Ms. Johnson here?
No, she is not. This is case 20-0086-C. This is Dr. Sharice Johnson. This came in on a third-party complaint filed by Mr. David Witham on October 28, 2020. Ms. Johnson is the current District 5 Gwinnett County School Board rep, and, sound like a broken record today, failed to file her DOI in a timely manner before taking contributions. There were 3 contributions, one in the loan to herself of $1,518.61, and then 2 other campaign contributions from 2 other sources prior to her filing her DOI to run for school board. She has agreed to pay a $1,000 civil penalty for violating the act 3 times, and will be paying $100 per month by the 10th day of every month until the balance is paid in full. So those are the violations for taking money prior to the DOI, and that's it for her.
Very good. What could be most efficient is if we make a motion, and maybe we hear all the cases and then make a motion at the end, if that's okay with the commissioners? Or do we want to do one by one?
It's whatever you want to do.
I'll just,
Well, let's do them one by one, just in case.
I'll say this,
Yeah,
Mr. Chairman.
there you go. Okay, never mind.
I don't,
I was calling back.
in principle, have any issues with that. I think we heard the position
It's
earlier
fine.
today
It's fine.
that our consent orders could be viewed as or have precedential value.
I don't buy that argument, I'll tell you.
I had issues with the argument as well, but
Is it in the statute?
so perhaps we have been, and I'm as responsible as anyone, perhaps we've been hasty in how we kind of run through these consent orders. So I'll, for whatever value that has, and perhaps none, but maybe we should be a little more deliberate when we consider these consent orders.
I'll have to look at the statute. I mean, to me, I view these consent orders like settlement agreements. I mean, they could have something, they could have the persuasive effect that we wanted to give them. But yeah, we have to be, I agree, we have to be mindful of the precedential.
I'm 100% agreeing with you. That's how I have viewed them as well.
Yeah, that's why I didn't get into that argument too much. Okay, well, in light of that, do we have commissioners have any questions about Mr. Johnson? Is it Miss or Miss Johnson?
Miss.
Miss Johnson. Dr. Johnson case. Okay, hearing that, I'll make a motion that we adopt the proposed consent order in the matter of, could you please say her first name for me?
Therese.
Therese Johnson in case number 20-0086-C.
Second.
We got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor, say aye. Aye. All opposed? Okay. Next up is case number 20-0057-C. We're ready when you are.
Okay. Sound is good? Okay. This is the matter of Montaigne Edwards, case number 20-0057-C. This complaint was filed by third party Triana James on August 28th, 2020. Respondent was served with it in June of 2020, and then we amended the complaint in February of 2021. Essentially, there were 4 late filed CCDRs. $500 in late fees were assessed, and $500 in civil penalties were assessed for a total of $1,000. Ms. Edwards accepted her call for the late filings and has already submitted payment for the total penalties.
All right, very good. Any questions for the commissioners? All right, anyone want to make a motion?
Make a motion that we approve the consent order. Second.
Okay, we got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor, say aye. Aye. All opposed? All right, motion carries. Consent order is adopted. And next up is in the matter of 20-0025-C.
This is in the matter of Raj Paul Sidhu. This complaint was filed by third party Jeffrey Wilbur, May 11th, 2020. Respondent was served February 19th, 2021 with an amended version of the complaint. Respondent ran for State Representative District 21. He late filed his CFDS and he late filed his December 31st, 2020 CCDR. Mr. Sidhu was more than easy to work with. He was assessed $250 in late fees and was not assessed a civil penalty.
Okay.
Did he offer a reason for why he filed late?
His late PFDS, I think he was just mistaken. The late filed December 31st, 2020 CCDR, I believe his, what he believed happened is he may have been on a different time zone and mistakenly filed it going off of the time zone he was in and not off of East Coast time.
So it was a matter of hours that he filed late?
That's what he believed. I'm going off of the records that we have, and our records show that it was filed a day late.
Okay, so it could be, 11:58 on one day versus 12:30 a.m. the next day, but it would still show a day late.
Correct. And, to take into account, he was only assessed $250 in late fees. There was no civil penalty assessed.
I move to accept the consent decree as presented.
All right, I'll second. Any discussion? Hearing none, I'll call the question. All in favor, say aye.
Aye.
All opposed? Any opposed? All right, motion carries 5-0. And just make sure, he did 4-0. Yeah, I think I might have said 5-0 earlier too, so make sure that's right.
Bob's here in spirit.
That's right. Okay, in the matter of Sharon Henderson, that's case number 20-0037-C.
So up until earlier this week, Ms. Henderson and I were negotiating consent order. She then decided that she wanted to proceed to a preliminary hearing. We, upon further reviewing, so I did take this case over from the previous attorney, upon reviewing further sort of the procedure of what had taken place in the prior attorney's work, we believe there may have been some service issues, so we went ahead and tabled any preliminary hearing for Ms. Henderson. And she has received notice of that, and we've been in contact, and I believe we'll address any outstanding issues in the next meeting.
Okay, so this one has been continued, is that what you said?
Yes.
Okay, all right. So next is the matter of Kenneth Henderson, and that's 20-0040-C.
This is a matter of Kenneth R. O. Henderson. The complaint was filed by third party Karen J. Osborne on July 10th, 2020. Mr. Henderson was served with the original complaint in August of 2020. We did an amended complaint service February of 2021. He was a candidate at that time in 2020 for Towns County Sheriff. He is currently the sheriff, so he was successful in that election. He late filed 5 CCDRs, his January, April, June, September, and October 2020 CCDRs. He was assessed $625 in late fees and $375 in civil penalties, totaling $1,000 in fines.
Okay. And it looks like he signed it. Did he have an attorney? He did, or did he not?
He did not have an attorney, no. And he did sign it I don't have an explanation for why the consent order looks a little different than the usual format. I'm not sure how he got it to look that way.
Okay. All right, any questions or discussion from the commissioners? All right, hearing none, I'll make the motion that we adopt the consent order in case number 20-004-C.
Second.
We got a motion and a second, any discussion? Hearing none, I'll call the question. All in favor, say aye. Aye. All opposed? All right, motion carries 4-0. So next up is in the matter of Dexter Wimbush, case number
21-0001-C.
Yes, so this is the matter of Dexter Wimbish. The complaint was filed by third party Carl Roeder on January 6, 2021. Mr. Wimbish was running in the special election for Griffin DA that occurred earlier this year in February. He had a late filed DOI, and upon review of his filings, he accepted contributions before the DOI, and then there was also a late PFDS as well. Mr. Wimbish had constant contact with me as I was investigating this. He had a fair amount of confusion about his responsibility for filing. I think he was corresponding with the local filing clerk who may have been giving him some misinformation. He did ultimately rectify most of his mistakes, and he was assessed a total fine of $1,500.
Okay. And he was not represented by a lawyer either?
No, he himself is a lawyer.
Okay, well, he signed it. Any questions?
Sure. So just real quickly, what are the background facts, if you can just run through them quickly? In the first paragraph of the finding of facts, the last sentence says, prior to this date, respondent reported accepting $18,421 in campaign contributions. Is there any dispute with him as to whether or not that's the amount that he accepted, and that he accepted those contributions prior to filing his DOI?
No, sir. He had some issues with filing the DOI. He self-reported those contributions, and it just kind of came down to the date that he filed, and unfortunately, there's nothing that can be done about that. He did file it late, and he self-reported receiving those contributions before then. He admitted that to me. He explained that he was told one thing by the local clerk, which was unfortunately incorrect. I did take that into account in assessing any fines.
Sure.
I guess, Commissioner Barton, for the sins of being a former prosecutor, every time one of these DA races, I get buzzed 30 times. In this particular case, it was a judicial circuit with an open vacancy. Mr. Wimbush was trying to file locally, even though he was a state official, and was only trying to file with one of the county clerks, and was getting some obviously incorrect information, which I think led to some of the issues that we see.
All right, any other questions? Anyone want to make a motion?
Yes, I move that we accept the consent order as stated in case number 21-0001-C in the matter of Dexter Wimbish.
Okay, I'll second that. Any discussion? Hearing none, I'll call the question. All in favor, say aye. Aye. All opposed? Okay, motion carries 4-0. So next I'll call in the matter of Gary Norton, 20-0070-C.
This is the matter of Gary Norton. The complaint in this matter was filed by third party Mark Stevens on September 21st, 2020. We did an amended complaint that was served in February of 2021. Mr. Norton is the mayor of Fort Wentworth. He has failed to file 3 CCDRs, I believe the dates of which were from 2019 and 2020. He similarly to the last case was misinformed by the clerk on what his filing responsibilities were. He was represented by an attorney Stephen Shear. I worked with Mr. Shear to educate Mr. Shear to then relay to Mr. Norton what his filing obligations are, and I think they've cleared all of that up. Mr. Norton was ultimately assessed $375 in civil penalties.
Okay. Did he sign this? The one I have, he did not sign.
We do have the signed version. He did send it in.
Got it.
We should be getting that to commission.
And did his attorney sign it as well?
I believe only Mr. Norton signed the consent.
All right. Is that an issue at all with, does his attorney need to sign it?
I didn't have any discussion with Mr. Shear about him signing the consent. Mr. Shear sort of took the case on. It was very casual. It was just sort of the go-between between me and Mr. Norton, and I didn't have any expectation that he was signing the consent.
I don't think there's even a place for him to have signed it.
I don't think so.
All right,
I'll make a motion, oh, sorry.
go ahead.
I'll make a motion that we approve the consent order that's been proposed and agreed to in case of Gary Norton, case number 20-00706. Second.
Okay, we got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor, say aye. Aye. All opposed? All right, motion carries 4-0. So next we've got administrative dismissals, and these are the ones that I've been reminded don't take any action by the commission. So we will listen and make sure that we don't have to take any action.
So I have three. The first one is Miss Karen White Ashley, case number 200032-C. We received a third-party complaint from Ms. Gonzalo James alleging that Ms. Ashley had bought votes through an advertisement advocating for free rent and that she had a late fee associated with her account. That late fee came because she filed her DOI and then went back and tried to file a zero report so she filed her DOI in March. She went back and tried to file the January 31st report. So it triggered a late fee because technically, whenever you file that late, it will trigger a late fee. She didn't have to file that report. So I went back and took it off the system for her, figured out that she didn't actually owe that. So that's why this case is being dismissed, because there was no violation of the act. The next one is Miss Lisa Culverhouse Joseph. This was, I think this finally closes out the Collins County Sheriff's race. I know Miss Goldberg just talked about it. Oh, we've got one more. But this was the one where one of the candidates filed a complaint on all the other candidates and himself. And this is Miss Joseph, who did not make it to the primary. But he alleged that she didn't file her PFDS, CCDRs, never filed a DOI. She did all those things. She actually filed an affidavit to not accept over $2,500, and there's no evidence to the contrary that she did. She called me and said, I spent, I think, $1,000 of my own money, and that was it. So there's no violations of the act here, so that's why this case is being administratively dismissed.
All right.
And the next one is in the matter of Linda Smith. This is case 200071-C. This was a third-party complaint filed by Mr. Mark Stevens, alleging that Ms. Smith had violated the act by failing to disclose contributions, failing to report in-kind contributions, failing to report expenditures, failing to register, and taking remuneration for official actions. Respondent in this case and the complainant are both members of the Port Wentworth City Council. As far as I can tell, I think this complaint centers around an attorney that was, there was a legal filing against Mr. Stevens. Ms. Smith retained that attorney in her personal capacity. There's no evidence to the contrary there. There was no campaign funds expended. There were no violations of the act going through her disclosures, none whatsoever. I think Mr. Stevens wanted to assume that she utilized campaign funds to hire this lawyer, and there was no evidence to indicate that was the case. So this case is being administratively dismissed because there are no violations of the act.
Okay.
And that should do it for me.
This may be a little out of order from what's on the agenda. I'm going by in order of case number, if that's okay. First administrative dismissal I have is in the matter of Curtin Summers, case number 20-0014-C. This complaint was filed by third party Alice Dormany. Ms. Dormany essentially alleged that Mr. Summers had failed to file CCDRs. He was running in a special election at the beginning of 2020. Without getting too deep into the weeds on all the dates that he was supposed to file. He was required to file a CCDR 15 days before that election, which was January 14th, 2020. He ended up filing on March 22nd, 2020. Some of these cases I took over from another attorney, so by the time I had reviewed everything, he had paid all of the fees. It looked like he had communicated with the commission to fix any of his mistakes. There were no substantive violations of any laws with any of the other CCDRs, as far as I could tell. All fees had been paid as of April 24th, 2020. No outstanding violations exist for Mr. Summers.
Okay. And so what's the next one that I have to call? I just want to make sure the order is.
Oh, the next one I've got is Gilstrap, Gregory Gilstrap, case number 20-0027C.
So what about the matter of Mary, how do you say that, Rob? That's on the next one on my agenda.
Mary Robichaud?
Yeah.
I can do that one if you prefer.
Uh,
I've got all of them here, I just
Okay, we'll just
organized
go,
them by
that's
case
fine,
number.
I'm just marking them off.
Okay.
Yeah.
Whatever's easiest for you. So the next one I've got is in the matter of Gregory B. Gilstrap, case number 20-0027. This complaint was filed by third party Joseph E. D. Corpo. It was essentially alleged by Mr. DeCarpo that there were numerous campaign signs all over Cobb County where a respondent was running for sheriff, and none of those campaign signs have been disclosed on CCDRs. I investigated, corresponded with an attorney for the respondent who explained to me that Mr. Gilstrap is sort of a repeat candidate for this office and he reuses the campaign signs every time he runs. Went back and looked at the records we have of his past CCDRs. He did report campaign signs on previous CCDRs that corresponded to what he used in the most recent campaign, so I found no violation of failure to report campaign signs for this election, for this cycle.
All right. How many times has the guy ran? He just literally uses the same signs.
He's run 3 or 4 times in Cobb County, I think.
Make sure you do not say what office you're running for, so you can just,
I think he generally runs for sheriff.
okay.
Yeah. Doesn't put the year though.
There you go, that's the way to save money on something.
So the next case I've got is in the matter of Kelly S. Johnson, case number 20-0031. This complaint was filed by third party Donzella James. Mr. Johnson ran for, I believe it was a Senate position, District 35, and it was alleged in the complaint that he was accepting contributions that were over the limit. Upon my investigation, there was one such contribution reported on his CCDRs. I then found that it was coming from his spouse, Mr. Rayford Johnson, and Mr. Johnson's also listed as respondent's spouse on his PFDS. So pursuant to OCGA 21541G, contribution limits don't apply to family members, and it's not a violation.
Okay.
Next one, in the matter of Linda J. Curtis, case number 20-0042-C. Ms. Curtis also ran in the Towns County Sheriff's race. The complaint, as Mr. Cusack already mentioned, was filed by Darren J. Osborne. He essentially alleged that the respondent failed to file her PFDS and failed to file any documents establishing a campaign committee, failed to file CCDRs, and failed to disclose expenditures. I looked into respondents' filings. Essentially, so with regards to the campaign committee allegation, the commission finds that her declaration of intent was sufficient because she identified herself as a candidate, so you don't necessarily have to file a registration. Identifying yourself as a candidate without establishing a committee is sufficient. so that she did not violate any laws by not necessarily filing a registration. With regards to the allegation of the PFDS, because she was a citizen who had not yet become a public official running at the county level, she was not required to file a PFDS quite yet. That's an interesting loophole that exists in the statute. And then with regards to failing to file any CCDR, she did correctly file an affidavit not to exceed $2,500 and therefore was not subject to all of the same reporting requirements as the rest of the candidates who did not file such affidavit. And there was no violations to be found there.
Okay.
Next one is in the matter of Bonnie T. Willis, case number 20-0047-C. This complaint was filed by third party Joe Beasley, who alleged that Ms. Willis failed to report contributions that she had reported on 2 business day reports, but then did not subsequently report on her CCDRs. So the way that requirement works is if you take in a certain amount of contributions, between the closing of a report and the time of the election, you have to report it on 2 business day reports. By the time I had investigated the case, the amount that was reported on the 2 business day reports had been subsequently reported on a CCDR, so she had gone ahead and made that amendment. Additionally, the amount in which was reported was less than, I believe, 5%, maybe even 1% of her total contributions, which the commission would consider a technical defect in terms of failing to file that on your CCDR. So considering that she had gone ahead and fixed it on her CCDR and it was a low amount, we found a violation.
Very good. Is that the last one?
No, I've got 3 more. Next one I've got is in the matter of Sandra Vincent, case number 20-0056-C. This complaint was filed by third party Gia Gakowski. The allegation was that Ms. Vincent failed to file her CCDRs, and Ms. Gakowski specifically was alleging she failed to file CCDRs dating back to 2012 and 2016. With regard to the 2012 filings, it's outside of our statute of limitation, so no violation there. In regards to the 2016, I investigated and determined that respondent filed an affidavit of exemption when she ran for District 2 City Council seat in 2013, which would have covered the 2016 filings, and there was therefore no violation there.
Very good.
Next one is in the matter of Kamali Varner, 20-0063-C. This complaint was also filed by Gia Gakowski, Ms. Varner, and Ms. Vincent, both City of McDonough City Councilwomen. So Ms. Gakowski, I guess, was keeping her thumb on everyone. She alleged that respondent failed to disclose a business interest on her 2019 PFDS. Specifically, the business interest is called Milner Phillips Strategic Solutions International, LLC. I took a look into this. It looks like what happened is the business was formed on December 30th, 2019, which technically would have required respondent to report it on her 2019 PFDS. However, because there was a 2-day differential between the requirement being for the 2019 PFDS and the 2020 PFDS, the commission, in its prosecutorial discretion, decided not to pursue any action.
All right.
And last one is in the matter of Mary Robichaud, case number 20-0075-C. This complaint was filed by third party Robert Lee, and it alleged that 2 allegations. One, that that Representative Robichaud held a town hall in June of 2020 in which she solicited campaign donations in violation of OCGA 21535. I took a look at the particular video that The complainant is referencing Ms. Robichaud did not in fact solicit any donations during the course of that video, so there's no violation there. The second allegation is that she failed to accurately report a loan, a $10,000 loan that was reported early on in her CCDRs and then later fell off of her CCDRs, which initially did look suspect to me, but upon communicating with the respondent, essentially what occurred there is she loaned her campaign that money and then forgave the loan. So she no longer expected to be paid back that $10,000 and she stopped reporting it as a loan on her CCDRs. My understanding is that there's a different way to report that on the CCDR so that it doesn't look quite as confusing or as suspect. And she's been instructed on how to do that in the future. And it's also my understanding that the new system will have a much better way to report that sort of thing so as not to cause confusion. But there is no violation there.
Got it. Is that the last one?
That's the last one.
Very good, thank you. All right, next up is the report of the executive secretary.
So I'll be pretty brief, it's fairly self-explanatory. Yesterday, one signing died, House Bill 81 was passed. We spent a number of months working with the legislature on this, the House and the Senate. Ultimately, they agreed to authorize a fiscal year 2022 budget, which saw us receive a 30, and my math is, but I think it's a 31% budget, agency-wide budget increase. So we're looking at bringing on a couple new auditors, potentially new attorneys, some additional support staff with that chunk of money. So a little less than $1 million they infused the budget with. Litigation updates. We had a case we filed against a group called the New Georgia Project, which we alleged was a unregistered so-called independent committee that was possibly coordinating. They filed a motion to quash subpoenas. This commission unanimously denied their motion to quash. They appealed that to the Gwinnett County Superior Court, citing First Amendment protections as well as some other overbroad arguments. The Gwinnett County Superior Court ruled with the commission, ordered them to turn over all documents in full. Mr. Fuller did a great job at that hearing. Normally that would be appealed to the Court of Appeals. However, they failed to pay the transmittal fee to the court in the timely manner. So my understanding is late April, there's a hearing in front of the Superior Court Judge in Gwinnett County as to why they should show cause. You shouldn't just dismiss their appeal out of hand and the document be turned over pursuant to our subpoena. Additionally, this board is familiar with litigation involving both New Georgia and AFG, as well as Third Sector Development, where a Fulton County Superior Court clerk ruled that she did not have jurisdiction to enforce our subpoenas when they were not complied with. The Court of Appeals handed down a unanimous ruling overturning, reversing, and remanding that. And so that has been sent back to Fulton County for a hearing on essentially relevance and any similar protections that we litigated in Gwinnett County. That was also a good case that Mr. Fuller argued. That one candidly had broader implications beyond just our agency, but really every regulatory agency in the state, every agency with oversight regarding enforcement of subpoenas. The new e-filing system is on course. The January report, we gave people the option, the limited group that filed that non-election year report. The next report will be June 30th. All officials that file statewide will file with the new system on June 30th, with the exception of the campaigns that use third-party vendors. That requires a special app, for a better lack of technological interface with the system. We secured an additional $300,000 as a one-time infusion from the legislature to help pay for that. That won't be ready quite in time for my comfort for June, so we're going to allow any candidates, campaigns, groups that use third-party vendors to file on the legacy system one last time. And then by the time we hit the end of the year, we should be fully integrated as far as campaign committees into the new e-file system. By that time, we should be through into phase 3 of our install, which involves transitioning the lobbyists from the old system to the new one, as well as the financial disclosure statements, which will phase into the new system for next year as well. So that's my report, Mr. Chairman.
Thank you. We appreciate your work. I know that getting the efforts on the bill were significant, and it's a lot of work, and so we appreciate you doing that. Okay, report of the Attorney General.
And sorry, it's Beth's first hearing. So like, normally I would just let Christian talk about the litigation, but I didn't want to like overload on her the first day. So I figured I'd like take the load off just a little bit the first time.
Well, I appreciate that. Thank you.
And Mr. Chairman, if I could back up, I did leave one thing off already.
Okay, go ahead.
I did want to, and I learned recently that this is something I'm supposed to do and I have not been doing in the past. But I do want to provide a special recognition by the agency to Mr. Fuller. Christian was here for 2 years with me, obviously for a number of years before that. But in the transition of what I think everyone on this board can classify as challenging times in the transition, Christian was definitely a source that we could lean on. He's doing just fine at Tech, but I did want to recognize him on behalf of the agency.
He did a tremendous job. I remember way back when calling him all the time about the issues we had.
I told him I'm going to keep calling him all the time, and he's promised that he would make himself available.
He's a great
for
resource.
anything we
So
need.
we're excited to have you, so talk to us.
I'm excited to be here, and Christian started today at Tech. Today is his first day, otherwise I think he would have really liked to be here. He's completed the transfer of getting all his files signed over to me, and I've had a chance to take a look at everything and trying to get fully abreast of everything. I'll add just a little comment to the reporting that's already happened on the Fulton County subpoenas. Just wanted to let you know that there are still some objections substantively to the subpoenas that have not been ruled on yet. So Judge Barber will have to issue another order, either enforcing the subpoena fully or deciding, that some of those objections, are or are not appropriate. Those are mainly just to overbreadth and privilege.
Okay.
So hopefully, we'll be able to get that final order entered fairly quickly now that the Court of Appeals is ruled. We'll have several matters coming up in Office of State Administrative hearings between now and the next meeting, and at that time I can hopefully give you a more comprehensive update on everything.
Very good.
Look forward to working with you.
We do as well.
Thanks.
All right, public comment.
Mr. Chalmers is actually in.
Okay. Erwin, can we get Mr. Chalmers on? Is he commenting on the AO or something else? Okay, well, we're not considering the AO. Okay.
Not yet, Don, hold on. Could you turn on the computer, sir?
What do I have to remind me? Computer audio?
Yeah.
Yeah, I've got that. I have that.
Hold on. I gotta double check.
It's been so long, I don't remember what Doug looks like. He's just a white screen up there.
Doug, can you try it one more time?
Sure. Mr. Chairman, can you hear me?
We can, Mr. Chalmers. We
Thank
miss you,
sir.
Doug. We can't see you.
Better
We
with
just...
the black screen. I look better that way.
All right, well, we're ready when you are.
First off, congratulations on your wedding.
Thank you.
Thought that was fantastic. But wanted to say congratulations to you.
I appreciate that.
With your permission, I'll spend less than 5 minutes just with some comments on the draft AO. I know it's being revised, but I thought it might be helpful to provide a couple of conceptual thoughts how this actually applied when lawyers are dealing with clients if they're setting up a campaign committee. Both the AO and the Abrams case sort of dealt with the question of whether or not candidates violate the act by accepting legal or compliance or other services before the DOI is filed. And the case, I think, was framed in
context of whether it was an expenditure. I didn't follow that. The rule is that it can't be a contribution. And so the question really applies in three factual circumstances. The first one is if services are provided, for example, legal advice is given or accounting or even consulting advice free of charge, then there's an exemption from the definition of contribution for that. So it wouldn't be a contribution, it wouldn't be a violation. The draft consent order actually said, though, if you provide services, including legal advice that are accepted, that's a violation. That's just not right. If there's no charge for it, it's provided free of charge, then there's no violation. So oftentimes we give the initial consultation, other lawyers do as well, for free. The second sort of factual scenario where it arises is if there is an expectation that the vendor will be paid later. And that is often usually what happens. We'll have an initial consultation, we'll basically set out a fee, we'll provide a scope of services, we'll tell them, by the way, you gotta get DOI on file, but we will bill them later for that. If we take the position that that provision of services is a contribution, then we're going to change the law dramatically in a number of different respects. But it would basically mean anytime any vendor provides services to a campaign, even if the expectation is later that it will be paid for, the initial provision of the services must be disclosed as a contribution, even though it's going to be an expenditure later. And what the commission has advised since back in the time when Commissioner Thompson was in the staff, is basically has been applied a commercially reasonable standard on the timing of the payment. If the payment is made within commercially reasonable terms, 30, 60 days, that sort of thing, then the initial provision of the services, which technically may be an advancement of credit, is not considered a contribution. And I would suggest to you that the same sort of thing should apply pre-DOI. We give legal services or accounting services that are expected to be paid for it. The expenditure should be disclosed later, but there is no contribution that's taking place, and that's no violation of the rule. And the third category, the last one, is what happens if the candidate makes a personal payment for those expenditures before the DOI is filed. And Mr. Lane was basically making the argument that you can never have an expenditure without a contribution, so therefore you can't make an expenditure before the DOI is filed. That's not really true, because the candidate's already got personal funds. If the candidate makes an expenditure for legal or other services before the DOI, is that a violation? But the point I wanted to make to the commission is the commission has not historically applied that consistently, and we could use some clarity on it. There is a rule right now, it's 189-3-.02, that says that when any person pays for goods on behalf of a candidate or a campaign, it's deemed a contribution. So if the candidate does that, it's typically deemed to be a contribution and has to be reported as an in-kind contribution during, the campaign. It's not clear if that applies prior to DOI being filed. And there's also some inconsistency in how the commission has handled payments for personal funds by the candidates. The act says that no state official or that person's campaign committee may accept a contribution during a legislative session. It also says that no candidate or that person's campaign committee may accept a contribution prior to filing a DOI. Last year, the commission concluded in AO 2020-01 that a candidate may spend personal funds on campaign expenses during the legislative session because that's not a contribution. The proposed AO that was tabled today says that a candidate may not spend personal funds on campaign expenses before filing a DOI because those are contributions. Those are inconsistent. And I would respectfully suggest to you that as a practical matter, the ruling that was applied last year should be applied this time. If a candidate makes personal expenditures for campaign expenses, in particular legal and compliance costs, before the DOI is filed, that should not be deemed to be a contribution, which is a violation. And as a practical matter, really is the only real solution, because when you go set up a campaign committee, you oftentimes need to get an address to put on the DOI. Well, you don't want to use your personal address sometimes for security reasons, so you want a PO box. To get the PO box, you have to pay for it. To get the PO box, sometimes they require you to incorporate the campaign committee and pay the Secretary of State for a certificate of incorporation first. So you're necessarily going to be making some expenditures and you're going to be getting some legal services and advice before that DOI goes on file with the required information. So I would respectfully suggest that in the drafting of this amended consent order, not consent order, excuse me, advisory opinion, that the reasoning that was used last year on the legislative session should be applied as well. That personal funds that are spent by a candidate before the DOI is spent are not deemed to be contributions. Thank you, sir.
Very good, thank you. And I think Commissioner Barnum has a question for you.
Mr. Chalmers, thank you very much for your comments. I wanted to get your thoughts about an issue that was discussed at some length today. There was a discussion about this idea of not being able to have expenditures without contributions, and I think you touched on that. I believe the position that was expressed in part today was you can't have an expenditure without contributions because a campaign can't go into the negative. And so in order to justifiably have an expenditure, you must, by definition, have some contribution. And I'm sure I'm not completely articulating the position, but I think I got the gist of it, that under the statute, under the act, you cannot have an expenditure unless you have a contribution. I think you touched on it, but I'm curious as your thoughts on that. Not that I don't want to suggest to you that, this is going to have any binding value or authority before this commission, but I am interested in your thoughts on that.
Yes, sir. And it's a good question. Just so I'm clear, I'm not going to be commenting on the Abrams case or anything along those lines, but with respect to the question that you posed, and the theory that an expenditure can only be made if there's been a contribution is absolutely correct if you're talking about an expenditure by the campaign committee. Because somehow that bank account, the campaign committee bank account, would have had to have been funded to spend money. That's not really where this issue pops up, though. The issue pops up because expenditures are made by third parties, either by the candidate or somebody supporting the candidate and acting in coordination with the candidate. And that expenditure by a third person is an in-kind contribution to the candidate. And so where the DOI issue pops up and we get tripped and trapped is when you go out and make necessary expenditures, either as the candidate before the campaign committee is set up, or as a vendor to go purchase, for example, a vendor you want to hire to go out and buy the URL Joe Smith or Stenton. If they make that expenditure before you have filed your DOI, technically under the commission rule I mentioned to you a second ago, that is an in-kind contribution. And the law says an in-kind contribution is the same as a regular contribution, and if you accept it back before the DOI is filed, it's a violation. Does that answer your question, sir?
I believe it does. Thank you.
Well, Mr. Chalmers, that was very helpful. We would invite you at our next meeting to attend and also provide comment, because as I've said many times, the most important thing is getting it right, and I think having your perspective would be helpful.
Thank you, sir.
All right, thank you. So with that, executive sessions next, we've already had that. I will make the motion to adjourn, if I can get a second.
Second.
We got the motion and a second. All in favor, say aye. Aye. All opposed? Okay, motion carries. Thank you. 4 o'clock's not bad, even though we didn't get through everything, but I have a feeling that